Well, good morning, everybody. And we've got a bright early start today before 10 o'clock and a varied program for you. But just a couple of announcements before we start. I won't be telling you about the fire drill, and I won't be inviting you to partake of a nice lunch because we're no longer, and haven't been for quite a long time, together in a building. We're all sitting comfortably at home or in our office watching the screen. So, what are my announcements? Well, first of all, I'd like to invite you to come along, and any colleagues who would be interested in family law, because we're having a family law webinar on Tuesday, the 16th of April. So it'll be a good update on various aspects of family law. The other thing I should mention is by all means, put any questions in the Q&A box during the course of any of the talks, and then the speaker will endeavor to answer those questions towards the end of the talk. So those are the two things I just wanted to let you know. Time is getting on, so I'd better hand over at this stage to our first speaker, Sarah Pinder of Goldsmiths Chambers. She's one of our regular speakers, so very familiar, I think, to most of you. And her talk is entitled A Look at Available Work and Business Categories, but it's going to focus on the health and care sector, which has been very available for a couple of years now. So over to you, Sarah.
Thank you. Thank you, Richard. I'll just get on with sharing the PowerPoint. And there we go. So that should all be there for you. Yes, good morning, everyone. Thank you, Richard, for starting us off. I hope everybody's sitting comfortably and ready to get stuck in to all of the really good topics that AstenJ have put together for today. So yeah, the title of my talk to take us until I think 10, I'm just going to remind myself of the time. Yeah, 10:25, so I've got that firmly at the forefront of my mind, is a look at available work and business categories. So I hope you will forgive me for not necessarily fulfilling that brief, but yeah, I sort of bit off a bit too much in providing the initial topic. I thought I would be able to cover a bit more of the other available work and business categories, but actually there's quite a lot to say with health and care visas, particularly with the announcements that are coming in very shortly. So I'll cover those within this talk quite as part of an overview as well. So in that sense, I hope you will find it useful. In terms of the health and care visas, basically just this slide to set out what they actually entail. And who they are for. So they allow medical professionals to come to or stay in the UK. So it's a category we'll see that you can switch into from the UK as well, to do an eligible job with the NHS, an NHS supplier, or in adult social care. Okay, so some general terms there, deliberately so. Medical professionals, we'll see particularly further in to the talk in terms of what particular positions this is for, but it's very wide-ranging within the sort of healthcare field. And again, eligible jobs, so that's deliberately general, but obviously specific in itself, that it's not just the profession, but also the particular positions, and as you can see, for particular employers. So we'll have a look in terms of the relevant criteria. It is quite nitty-gritty, though you will see there is a lot of advantages to this route, a lot of quite a lot of flexibility built in, for example, lower fee application fees and so on, but similarly it's also quite prescribed in the way that the skilled worker route has become so over the years. And then we'll just really throughout try and identify really what to look out for by way of procedure and advantage, for example, that you can be mindful of in terms of tailoring that to a particular client base, but also what you've got to be aware of going forward. And that will also touch on, as I mentioned, the recent announcements and that actually involve quite a few new restrictions. In terms of this slide, I just wanted to start off with some statistics. It gives us some background as to this route. As Richard mentioned, it has really propelled in terms of numbers of visa applications, and this really does illustrate that quite nicely for us. I took the figures that I'm going to read out to you to just help read those tables from this article that you've got hyperlinked on this slide. So it's a Sky News article, but quite a detailed sort of overview and sort of recording how the route's being utilised so far. Also foreshadowing some of the concerns with that route, but obviously Sky News, it does come with a pinch of salt in terms of any journalistic views or analysis of that you just need to be mindful of. But as you will see at the bottom of that slide, the two tables are taken from the Home Office, are effectively analysis of the Home Office statistics. So in that sense, I'm quite confident, certainly, that the statistics are reliable. But effectively, you'll see that in both slides, the huge increase in terms of proportion, in terms of health and care visas of the total skilled visa grants, number of visas granted. So in the year to June 2023, on the table that you've got on the right hand side of your screen, you see the total skill visas there, 189.5k, of which, if you go 3 lines down in terms of the numbers, health and care visas are 120k. Okay, so that's for that first half of 2023. And again, the table on the left hand side of your side, you see the increase between one year to the next. So from 2022, we've got skilled worker health and care basically amounting to 46.8k, and then in 2023 we're at 120. So it's really sort of exponentially risen in terms of numbers. And just a few more statistics that I've just got in my own notes that I thought, again, would just be worth you bearing in mind. So again, the context. So the government added senior care workers to the shortage occupation list in 2021, followed by care workers in February 2022. So again, a sort of incremental decrease in regulation in terms of making that position available for the visas, with the shortage occupation list being used. So senior care workers in the first instance, trying to limit it to those positions, those more senior positions, but then realising again the need for care workers further down in the hierarchy, and them being added in February of 2022. And so then again, you can, with the sort of time lapse to process those and for applications to start coming in, you can see what's led to that huge rise in 2023. But again, the context that I want to stress, that I think we just all need to be mindful of, this is all and reported on in this article, but also in other resources that I will give you further into the talk. It's all in the bid to fill rising numbers of vacancies since Brexit, okay, and the end of the free movement. So again, traditionally, these types of positions had become filled from EEA and EU workers coming to fill those, and we've seen a drastic decrease in those positions being filled by such workers. So that's led, as I said, to the rapid rise that we've looked at already. And the top 3 countries, this I thought was also interesting to share, top 3 countries as reported on in this article, so I haven't fact-checked, if you like, in the statistics, but as I said, Home Office statistics being used as far as I can tell. Top 3 countries for health and care visas issued in the last year, so that's in the last year from the article. tail end of last year, are for India 30k, Nigeria 18k, and Zimbabwe 17k. Okay, and that's also the last sort of contextual statistic, or sort of framework. That's also when vacancies remain higher than pre-pandemic levels. Okay, so recruitment is slower than pre-pandemic levels. So we've seen a huge rise in these visas. Obviously, I can't compare that huge rise in visas with the number that were filled with EEA, EU workers before, or the rate of that recruitment within those workers. But again, that gives you some form of context, which I think is useful. So in that context, what does this mean? So effectively, who is this visa for? How can we utilize it? And how is it going to be relevant really for some years to come? So again, starting with the overview of the relevant criteria, the route itself is health and care visa, but it comes under really the framework of the skilled worker route. So I focused on the health and care visa criteria. In some instances, I've cross-referred you to the skilled worker routes, but do go through the skilled worker other sort of common criteria as well if you are to advise on this route as well. So it's important to really cross-reference both sets of criteria. And in terms of eligibility, as we just looked very briefly in terms of that first bullet point in the first slide, you've got a paraphrase list there in the middle of your slide. So a qualified doctor, nurse, health professional, or adult social care professional. So that's your sort of straightforward, quite delineated categories. And then the criteria continue in terms of what job they are proposing to fill. So they're either working if they're switching, or they are to work in an eligible health or social care job for a UK employer that's been approved by the Home Office. And they have to have a certificate of sponsorship with the required information, again, continuing with the skilled worker route and tier 2 previously to that, with quite a lot of specified information that needs to be in there. They will need to be paid, or they are paid, a minimum salary, and how much that salary is depends on the work done, and we'll come to that in a bit more detail later on. So again, similarities there to the skilled worker routes in terms of the same framework being utilised, certificate of sponsorship, etc., but also needing to check the positions, needing to check the employer, and so forth. In terms of what you get as an applicant working through this visa, you can get granted up to 5 years, and that can be renewed. There's no maximum renewal time, as you may have been familiar with in terms of the restrictions that did creep in eventually, but that have since been relaxed a bit in terms of the skilled worker route and tier 2. You could, often ICT, for example, intercompany transfer, you had a maximum of 9 years, so that you couldn't reach ILR, again seen as a bit of a deterrent. So there's no such maximum there, and similarly no cooling off period, so you don't have to go out and spend some time outside of the UK before you can then get renewals. And you also can be eligible for ILR after 5 years. Again, some intricacies that it's not possible to fully detail for you in this talk, but it's fairly generous in terms of being able to combine the different types of leaves to count towards ILR. So even if a person is only recently switching into this visa, they may have held another skilled worker, for example, visa previously, and you can combine those. So it's useful to look into that if you get any queries as to when they might qualify for ILR. Now, this is one of the most important changes that you need to be aware of. So I've put that in red. So up until the 11th of March, so it's still possible now, eligible dependents can qualify in line of main applicants. So a person applying today for a health and care visa, whether in country or out, will be permitted to effectively apply for their dependents in line with them, and they, subject to the criteria being met, should then be granted. But that is changing from the 11th of March. So that was announced last year in terms of a plan to not allow dependents to come. It was also a wider plan, for example, in relation to students. And there was some pushback. There still continues to be some pushback about that for obvious reasons, but that was confirmed in the context of health and care visas on the 30th of January of 2024. So the title that you've got, Home Secretary underlines commitment to cut net migration, in italics and underlined, is a link to that Home Office press release, in effect, that statement confirming that, and then the date by which that is to come into being is the 11th of March of 2024. So I think it's later said I think it's later detailed in another slide in terms of that not having retrospective effect, but I'll just mention that now. So it is only for new applicants to this visa from the 11th of March onwards. So persons who have come already, who have that visa already, who applied prior to the 11th of March, but for whatever reason didn't apply with their family, for example, but got the visa, they will be allowed to apply for their eligible dependents to then join them or to stay with them. So it is only for those that are effectively new applicants that get caught by this date of the 11th of March. Okay, so that is a massive change, one which I'll touch on later in terms of that potentially having an impact really on the number of visas that might be taken up. So continuing with just really the overview of what's required as part of this route. So one advantage, as you can see in the first bullet point, is that there's no healthcare surcharge. So the IHS is not charged to applicants applying through this route. So that's one financial incentive versus the skilled worker route, for example. But again, obviously, you then need to make sure that you qualify for the eligibility in this particular visa. But, you know, again, for a family with dependents and so on, that is, you know, quite a substantial saving there, less of an administrative step as well. You do have to, as I'm focusing on main applicants here, but you do have to show the English language B1 requirement, unless you come from a country that it's exempt. So again, majority English speaking country that's on the list, etc. All common criteria that you're familiar with in across really what we know as the points-based system. But just a qualification there for doctors, dentists, nurse and midwife, so sort of the more sort of qualified, regulated of the professions that are eligible for this route, they can just rely on their English language assessment that may have been accepted as part of their relevant regulatory professional body. Okay, so that means that if you've got an overseas doctor, an overseas qualified doctor, in getting their qualifications approved to practice by the regulating body here, they may have had to show their level of English by whatever means that regulatory body requires, and so that is sufficient for the purposes of the visa application. So it may not be, you know, it may not be relevant in a particular client's case, but that's a useful thing to just double check to avoid having to go through the test provisions and so on. In terms of looking up whether the work position is eligible, you've got, again, the same framework as a skilled worker application. So it's the occupation coding tool, again, hyperlinked, and then other website pages there for you to consult. So really it's just, you know, going through that and checking what position, you know, as you've got advertised from the employer, or, you know, what position the employer wants to fill, or the applicant wants to apply for, and then cross-referencing that as best as you can against those resources. The last 2 bullet points really, I've paraphrased to for you to have as wide an overview as possible in terms of the eligible positions. But it is important to take home that this is paraphrasing, okay? So look at the guidance, look at the rules, look at the coding tools and all of those resources together, because, you know, I may have missed a particular position or just termed it generally just for ease. So I can't stress that enough. But it gives you an overview for today's purposes. And effectively, you've kind of got 2 categories. So the penultimate bullet point on that list is healthcare, nursing, residential managers. Okay, so really anybody involved in sort of health and care work in nursing homes, in residential care homes, that sort of environment. Medical practitioners, pharmacists, nurses, including dental nurses, midwives, social workers, paramedics, medical and dental technicians, nursing auxiliaries and assistants, and then senior in brackets, care workers, only in brackets because you saw through the statistics in terms of that progression with both positions put in. So it's care workers, including senior care workers and home carers. Okay, so really quite a broad range of health and care professionals, right up to, you know, the most qualified in terms of doctors, for example, right up to the bottom in terms of skill set, in terms of what is required for those particular positions like home carers and so on. So really a broad range. And then the last bullet point, and I've just put it that way because effectively it's a sort of catch-all provision. So even when the first list that I've just read out is fairly broad and you know, covers a whole range of practitioners, you've still got a catch-all group where, you know, if you're not sure that you fit in within the first sets of you know, eligibility position, you might then still be able to show that it's nonetheless qualifying for this visa. So that is, again, paraphrase, health professionals that are not elsewhere classified. Okay, so if you're not classified in that first sets of in that first list, then you know, it might still be possible. And again, these are the sorts of examples that are given. So audiologists, occupational health advisors, therapy professionals. So again, therapy professionals really covers a whole wide range of practitioners, again, that are not elsewhere classified. And again, some examples are given: osteopaths, psychotherapists, health associate professionals, not elsewhere classified. So hugely broad there. What I would say though, because I'm mindful that, you know, the health and therapy sort of sector, it has grown exponentially really over some years in terms of, you know, looking at well-being, looking at sort of para health, if I can put it that way, elements of our lives and our health and our well-being and so forth. But what you would still need to remember is obviously that then they need to be employed by a particular employer, so by the NHS, a supplier to the NHS, or another approved employer. So, you know, it wouldn't necessarily cover a lot of perhaps more the private companies, the private industry therapy professionals that otherwise might otherwise on the face qualify for this. So just bear that in mind. But otherwise, I think, and I think you will agree, it's a huge range there. Sorry, have I gone one too far? No. So focusing a bit more in detail in terms of the employer. So the employer needs to be an approved UK health and care sector employer / sponsor. You have the list of the eligible employers in grey halfway down the slide in the guidance there. That's hyperlinked as well to take you to that. We've already looked at, and I've already mentioned several times, but I'll mention it again just really to stress it: NHS an organisation providing medical services to the NHS, and an organisation providing adult social care. Okay. If they're not currently approved, they can apply for a sponsor license if they're eligible to do so. And again, a very general summary of the salary levels. We're going to look at that in a bit more detail in the next slide, I think. Usually a minimum salary of 26,200 per annum, okay? Or the going rate if the position attracts a higher salary. So again, just a small amount of time spent on this to help you again conceptualize that. So 26,200 per annum is effectively the minimum. But if a particular position is set out as having a going rate, so a type of therapist, for example, would usually earn more than 26,200, then it's the going rate that applies. So it's always the higher amount of the two, if there is a going rate. And again, the guidance sets out or the occupation code set out the going rate if there is one. Okay, so again, a link there for you in the going rate. For the going rates. In terms of the salary level, so just spending a bit of time on this, but it's all sort of in a vacuum in terms of the relevant criteria where some reductions in salary might apply. And again, it's paraphrased for you. Okay, so it's set down in a lot more detail in the guidance, but I've tried to distill it for you in that one slide. So go to the source if you're unsure or if you need to check things very carefully. But also, I did not check, and I realized that only this morning. I will try and double check it later on today for you, and I can place something in the chat box if it is different. I forgot to check whether these reductions in salary that are permitted, if these certain criteria are met, are affected by the changes that are coming in on the 11th of March. I saw in the announcement that the 20% reduction in going rate for the skilled worker route will no longer apply, but I can't remember now, and I didn't think to check whether that's just skilled worker route outside of the health and care visa or whether it is specifically for the health and care visa. So all of this information here in this slide is subject to to checking the new changes that are coming in on the 11th of March. So if you can just make a note for that for yourselves, and I will try and double check that and confirm that before the end of today. Okay, but basically, subject to that check, there is flexibility as there is built into the skilled worker route as well, in terms of the salary, the minimum salary that needs to be paid. So as mentioned, 26,200 or the going rate is your baseline. But you effectively have a range of between 70 to 90% of the usual going rate if the job is with a salary of at least 20,960. Okay, so you can't have reductions if the salary is sort of below that. And then what reduction you can have depends on certain specific criteria. So job is in the shortage occupation, you can be paid 80% of the going rate. So I think this is the one that may be affected by the new changes. I found it a bit worrying, really, in terms of sort of exploitation, and I haven't touched on exploitation yet, but in my mind, I did find that worrying from an applicant point of view, that obviously, okay, there's a shortage occupation, but really for the person filling that job, why should they agree to, obviously it's a matter for them whether they agree to it, but why should effectively the employer be able to offer a salary, because the visa will still qualify, of 80% of the going rate? Usually a shortage occupation, again, just applying sort of market labor offer and demand, rules. If you've got a shortage occupation, usually, it would attract a higher salary because you're having to pay a higher salary in order to recruit into those positions. And again, with the context of the strikes that we've had last year and disputes in terms of pay, I did find that quite difficult to really come to terms with, that's right. In terms of whether that's obviously still going to be the case, as I said, we'll need to check that. But otherwise, if you're under 26, you're studying, or you're a recent graduate, or you're in professional training, again, you can have a higher decrease in salary. So the employer can, again, pay 70% less than the or rather can pay 70% of the going rate to that employee. But in red, again, just a flag that that does come with a maximum stay, I think, in that level of salary, in that position, of a maximum of 4 years. I don't think there's any restriction then, renewing outside of those 4 years if you're not then relying on a reduction in the going rate. But again, worth double checking that, because it can get quite nitty gritty. And then the last two really are sort of science and sort of PhD level qualifications that you have: a science, technology, engineering, or maths, so STEM PhD level qualification that's relevant to the job, but also if it's not relevant to this, so in any other subject, your salary must be at least 23,580, and then there's a reduction depending on the study subject of between 80 and 90, and then a postdoctoral position in a scientific role will also attract a potential 70% of that going rate. Okay, so quite nitty gritty, but some advantages there, depending on where you're really, who you're acting for. Obviously, for employers, it's more advantageous; for applicants, less so. But again, can provide some flexibility that the applicants may want as well to secure their entry into the UK. So this is just focusing really on the new rules that are coming in on the 11th of March. Again, just really providing you with that overview. So go to the statement of changes. It's there, hyperlinked in grey, with effect from the 11th of March. Explanatory memorandum, so the part in italic there is lifted from the explanatory memorandum, so it's a direct quote, and it's in response to high levels of non-compliance and worker exploitation and abuse, as well as an unsustainable levels of demand that these changes have effectively been brought in. In the year ending September 2023, 83k or so visas were granted for care workers, and a further 18k plus visas for senior care workers, comprising 30% of all work visa granted. So again, same sorts of context and statistics that we saw earlier. In addition, there were 250k plus visas granted for work-related dependents, 69% of which were for health and care worker dependents. So it's a lot to unpack there, and really little, in my view, acknowledgement in terms of the worker exploitation. So if you go back to that Sky News article, there's sort of more references there, and then there's other resources that have covered this. Since the sort of exponential rise in the health and care visa, it has been reported that many employers, many organisations have effectively promised certain salaries, but then don't pay those, that there's been really quite worrying concerns in terms of persons being, falsely misled into coming to the UK for particular positions, and then the position on the ground is very different. And that will happen really with these sorts of sectors. There was a concern previously to this visa, but that really has exacerbated the problem with the need for recruitment and the fast pace that's been tried to be resolved. But why I say there's quite a lot of unpicking to do is because, again, the focus of the government's changes is on the work-related dependence. So really, again, you can see sort of the policy intentions there is to drive a net decrease in migration, and again, that's been very clear in terms of the policy announcements, and it's difficult to see how that necessarily is going to obviously assist in curbing the levels of exploitation that we've seen so far. So some worrying changes in terms of this sector and how this sector will manage with those changes. The more regulatory changes that are addressed to curbing the exploitation, and which in my view are positive, is that care providers that seek to recruit through this route and sponsor such workers, they will need to now be registered by the Care Quality with the Care Quality Commission, okay, and currently carrying on a regulated activity. That is not retrospective though, so again will only apply for positions to be filled and that form the basis of applications from the 11th of March, okay? So care workers that are already in this route, that obtained a visa that employers managed to sponsor prior to the 11th of March, and then they come to extend their permission to stay further down the line, they won't need to meet this criteria of the register. So it is only for new applicants, and you know, to go forward with those new applicants in their journey to the UK. So again, extensions, applications for settlement for those already here who might not be so registered won't be affected. So that is positive. I don't have the specialist knowledge in terms of the care sector to give you an idea as to how many providers might already be registered with the Care Quality Commission, and you know, whether that will then cause a difficulty in terms of recruitment and vacancies and so forth, but something to watch out for to see if that does cause a dip in the numbers of visas being applied for, but also causes a problem with positions that otherwise would have been filled and that aren't necessarily causing a problem on the exploitation front. And as mentioned already, so the last bullet point in terms of the changes removing the provisions for dependents to accompany or join workers sponsored in these occupation codes, okay? The caveat is there in brackets, other than providing for children born in the UK. So obviously if you've come here as a health and care worker with a visa granted to you after the 11th of March, with an application having been made after the 11th of March, you come on your own, you meet someone, you have a child, that's fine. That child, if they fall to be considered in line with that visa holder, then they will have no problems regularizing or being provided for in line with the main applicant. But effectively that care worker with existing children back home would not be able to bring their children in, and I think that's where we're going to see a lot of changes, possibly with this route being utilised, and perhaps query how long those changes will remain in force. So just about 10 minutes left, and I've got a few more slides to get through, but some are summarising really what we've covered already. So this slide just giving you a bit more information in terms of the procedure, again really focusing on the advantages of this route, both from an applicant point of view, but also really as a design in order to get workers to fill the positions that are in dire need of filling. So the cost of the application is really quite a contrast. So if you want to apply for up to 3 years, it's 284 per person, and then more than 3 years, it's 551 per person. So huge difference in terms of the application fees compared to other work categories, to other limited leave to enter or remain applications. Financial eligibility requirements, really it's much of the same as we're already familiar with within the points-based system, so I won't go into any more detail on that, and it's a paraphrase again there, but again in red, just a reminder, I've detailed obviously what applies to dependents, but that is only obviously applicable until the new changes come in, and unless the applicant has been in the UK with a valid visa for at least 12 months. So again, there's the same more relaxed regime in terms of financial eligibility requirements if you're already here. And again, the employer can cover the applicant's costs and confirm that in the certificate of sponsorship. So the same sort of framework applies as we've seen in other routes under the skilled worker route. And then the switching provisions there, I won't again speak to them. And again, it's a paraphrase, so do check carefully if you need to advise whether someone can switch or not, but it's more of the same. So you've got student specific provisions that are there under the first bullet point, and then more generally, so visit visa, short-term student visas, parent of a child student visas, seasonal worker, domestic worker on immigration bail, or if you have leave granted to you effectively outside of the rules on compassionate grounds, so sort of DLR type leave, if that still exists nowadays, then you cannot switch in country. But otherwise, really, it's again quite in line with the other switching provisions of the skilled worker route, and a lot of categories will be able to switch into this route if they so wish to. The last bullet point I just want you to note, so there's a separate regime for updating visas. I haven't, just again through the difficulties in fitting in too much for the slot that we've got, I haven't given you a separate slide on this, really choosing to focus on how to enter this route, how to make use of this route initially. But effectively, once you've got a health and care visa, for a particular job, for a particular employer, there are then, like there are with the skilled worker route, there are then specific provisions where you may or you may not need to notify the Home Office of a change. So for example, this is not an example of the specific criteria here, but for example, if you got that visa for a particular job for a particular employer, if you change employers, you may need to notify the Home Office, but if it's the same position, that's all that you need to do. If you change I think positions within the same employer, you don't need to notify the Home Office as long as it's a position that then remains eligible. So it's also a position that's eligible. So that you've got various permutations depending on what the job change is in terms of position, if there is a change, or what where are you moving to? Are you moving across employers? If it's an employer that's also approved, and so on. So you've got to check that quite carefully, whether there's effectively an onus on the applicant to notify. But also there were, just from memory, I think when it applied to dependents, there were provisions or circumstances where you didn't need to notify as the event happened, but you could then notify as you seek an extension, for example. So quite detailed nitty-gritty provisions there that you just ought to be aware of. So if you're advising, for example, someone on a grant of their health and care visa, it may be worth making them aware, FYI, if you change position XYZ, you need to do that, or particularly if you're advising employers as well. But that's all that I can say really on that, because it is too kind of nitty-gritty and dependent on varieties of factors. So on this next slide, I'm just summarizing really the advantages that this route has provided applicants and employers with, and some we haven't touched on before. So you have a fast track processing of visa applications. I haven't seen anything to suggest that that's going to change in light of the restrictions that we've already touched on. Lower application fees, we've seen that. Exemption from the IHS, we've seen that. But then the next two, I haven't touched on. So you also have a dedicated NHS support and visa processing team, enabling visa applicants and sponsors to contact UKVI specialist team if they've got any issue with the application process or the eligibility. So that's again worth bearing in mind, particularly if you advise employers or, you know, some employers are sort of venturing into this, not having done it before, perhaps contractors to the NHS, for example. But also, forgive me, in February of last year, the Home Office removed, and you may not be familiar with this criteria depending on how much business and skilled worker work you do, but they removed the 20-hour cap on supplementary work that sponsored workers are otherwise allowed to do. So in a nutshell, if you get a health and care worker visa, you were, prior to February 2023, allowed to work in a different capacity that's effectively not regulated, you know, for a particular employer or in a particular position for up to 20 hours a week. That cap is removed, but provided that any hours worked beyond the 20 are in a position that qualifies for a healthcare visa. So the sort of, you know, a relaxation, but nonetheless a caveat applied to that. But again, that can be useful for healthcare professionals that may, you know, do some work on a private basis and can do so up to 20 hours a week. Where it's effectively unregulated, it's supplementary in a different capacity altogether, potentially, and then any number of hours beyond that 20-hour cap from the February 2023 does have to be effectively in line with something that would otherwise qualify. So it could still be different work to the position that they are working in for the purposes of the visa, but it would still need to be an activity, an area that effectively would otherwise qualify for a visa. Okay, and again, may need to update their visas if additional work, but conditions vary, and that was due to be reviewed in August 23. I don't think I've seen anything that changes that, but again, it's worth double checking if you've got a specific case that raises this. Usually, in my experience, persons work enough hours in their positions that get them this visa, so it doesn't really arise that often. So just a few things on best practice to start concluding our talk. Really just highlighting, so, you know, if you've had, we've all had experience, no doubt, of the NHS and, you know, health and care services in our own perhaps personal or sort of family life, but it's a big machinery. Okay, so you'll have the more straightforward NHS entities, you know, NHS trusts and so on, primary care services, etc. But you will then within that have all sorts of you know, sort of not third party but subcontracting organizations that will be private organizations or private companies, but nonetheless who are providing those healthcare services contracted with the NHS. So if the visa is to work for such a private organization or company, it's my view in those working in this area that it's best to provide the explanation, the narrative, and any documentary evidence to explain that relationship between the private organization, private company, and effectively the NHS, okay? Because it may not be obvious from either the name of the company, if the Home Office looks up that company from their website, whatever the case may be. So it's important to try and just you know, establish that route that this contractor, you know, provides those healthcare services to the NHS. So you may need, if you're acting for an applicant, you may need some extra information and documents from the employer. Okay. As mentioned, the increase in the visa applications have also triggered the concerns of potential / actual exploitation. So you've got some resources in the last slide that chart that, in particular the Commons Library resources. So some real concerns there. Be live to that. Be live if you particularly act for applicants, because that is creeping in much more, and it's always tricky territory to navigate with, obviously on the one hand the employee wanting to maintain their livelihood, wanting to maintain some income, etc., but with flags all sorts of concerns in terms of potential exploitation. In terms of whether you're considering, go for the skilled worker route or healthcare visa work route, do remember, again, just highlighting that penultimate bullet point, the health and care visa is specifically to medical professionals working in eligible health and care roles. So persons that may be working for the NHS, for example, in different capacities. You might have cleaners through contractors, you might have electricians, you might have all sorts of other professionals that are within that NHS sector, but they wouldn't qualify for the health and care visa. So the focus is not on the sort of NHS as the employer or the contractor, but actually the position. So in those latter cases, you would want to go for the skilled worker route if that applies. In terms of those are the flags that I wanted to set out in terms of best practice. Another slide for you. I do love my stats to place things into context, but again, you really see, really just looking at the first 2 quarters of 2023, I haven't seen updated analysis in table format since then, but huge increases in those first 2 quarters. So it'd be interesting to see the last 2 quarters of 2023, with the last quarter probably not being released yet, to see, I suspect it's more of the same, and then obviously to see what happens this year with those changes. Sorry, I'm going backwards and forwards with my slides. Useful resources for you to check there. So guidance, really indispensable in terms of checking the nitty-gritty in terms of salary. For example, it will have links to the code tools as well, health and care visa guidance also, and then the 2 House of Commons Library resources there. The 3rd of October 2023 one is the one that I reference in the context of potential or actual exploitation, and then the latter one is really drawing together the changes that were announced from the 30th of January, and it also references changes in relation to the skilled worker route more generally. So I hope that you found this talk useful as a way in, or as a refresher if you are new to this, if you are experiencing this route already. Questions, as we will, sorry, I just stopped sharing now. Questions we will field later in the panel session this afternoon, if you do have some. So as Richard mentioned, if you have some, I think I've seen a number 2 in the Q&A box, so there must be at least 2 potentially for me already. But if you haven't placed your question yet, do put it into the Q&A box, and we'll come back to that this afternoon, and I will also refresh my mind in terms of those changes on the salary levels and confirm that later and in the chat box. So thank you very much, and I will, Richard popping up just in time. Hand over back to Richard.
Well, here I am popping up, and to say thank you very much indeed for that excellent talk, Sarah, and a very topical talk, in fact, because there's been a lot of publicity about the health and care sector in the last few months, and exploitation in particular has been getting into the newspapers. Anyway, my own talk is coming up, and it's a mishmash, a hodgepodge of unrelated topics, which I hope you'll find interesting, or some of them at least. Now, I'm going to do something which I haven't done before. I'm really a novice when it comes to digital technology, but I'm going to share my screen with my course notes, which I think will be more convenient for the participants to take a look at on the screen as I'm talking, rather than having to look at them and also see just me on the screen. So let's see what I can do. Up there's the brochure. I'm going to share that. And here we are. I'll see if I can scroll down a bit. Let me see. Right. Here we go. I have to come down past Sarah's talk, and here's mine. Okay, well, the first topic is the rather shockingly entitled Hitting Council for Costs. And this was prompted by a little-known addition to the Tribunals, Courts and Enforcement Act, 2007, made by the Nationality and Borders Act. And this is a new charging power in respect of wasted resources. If the wastage was caused by a relevant participant acting improperly, unreasonably, or negligently. And a relevant participant includes anyone with a right of audience or a right to conduct the proceedings on behalf of a party. Now, are Home Office presenting officers caught by this? Surely they have a right to conduct proceedings on behalf of the Secretary of State. Well, if you look at the existing wasted costs orders, which are found, for example, at Rule 9 of the Tribunal Procedure Rules for the first tier, the 2014 rules, they're not caught by the provisions for wasted costs orders. And if we just scroll down a little bit further, you'll see why HOPOs are not caught out by the regime for wasted costs or unreasonable costs orders. And this goes back to a presidential guidance note by the presidents of both the first tier and upper tribunals, that time Mr. Clements and Mr. Justice McCluskey, at a joint hearing of a case called Awua and others. And they concluded that wasted costs orders cannot be issued against Home Office presenting officers because the Secretary of State and the Secretary of State alone is fully responsible for the actions of HOPOs. No separate individual liability or responsibility attaches to such persons. As the Secretary of State and the HOPO are indistinguishable in law, it follows that in the language of Section 29(6) of the 2007 Act, a HOPO does not conduct proceedings on behalf of the Secretary of State. Now, the corollary of that must be that the Secretary of State can, well, now himself, be charged under Section 25A for wasting resources. Now, there's, I think I can skip over the next couple of paragraphs. It's a bit technical. Now, what I'm coming to is the next full paragraph. At all events, HOPOs can breathe a sigh of relief, as they will not have to dig into their pockets, whether it be costs or resources that are wasted. Now, what is the difference between wasted costs and wasted resources? Now, wasted costs are costs unnecessarily incurred by one party because the other party has needlessly protracted the proceedings. So perhaps the Home Office might be more liable for that because they, very late in the day, concede, they withdraw the decision, or they put up very feeble arguments, even in the respondent's review, which turn out to be hopeless when the appeal is actually heard. But it can work the other way around as well. So wasted resources might mean that needlessly taking up the tribunal's time with hopeless appeals and applications. Now, if that's what wasted resources mean, it could give representatives pause before they initiate further applications or appeals. I'll be coming to this in my next talk as well, but it's very often the case that repeated applications are made by overstayers, and you'll see that in the immigration history, which you get in the respondent's bundle, and also it's part of the refusal letter. And you'll see that somebody could have been in the UK for years and years, and they've been unlawfully present for most of the time. They may well have come as visitors to begin with, but after 6 months, they became overstayers. They're still here, and they're still making applications. And unless they've got hitched up to a British citizen or they've got British children, if all they've got is their private life in the UK, they're not going to succeed. But that doesn't stop them making repeated applications and hoping to get to the 20-year point when they can apply for leave under the 20-year rule. Anyway, perhaps that's not very likely to occur, that representatives will be charged with wasting resources. Just a possibility. However, I'll finish with this, a note of caution to independent barristers, because unlike presenting officers, they surely are not fused with the Secretary of State as one flesh, as it were, like man and wife in the Bible. They are surely instructed by the Secretary of State to represent him. And so they are the opposite of presenting officers, and they would potentially be liable for wasted costs or wasted resources orders, whereas a hoppo in the same situation would get off scot-free. Well, I don't think that thought is going to deter many barristers in independent practice from appearing on behalf of the Home Office, as many do, particularly now that there's a shortage of hoppos, and indeed often at appeals, there's nobody to represent the Secretary of State. Well, the next topic, quite unrelated, is civil penalties. Now, those are penalties incurred by employers if they employ workers who either are in the UK unlawfully, or if they are here lawfully, they don't have a right to work as part of their conditions. So let's scroll on down. And here, I'm a little bit out of date in the first paragraph. I wrote this a few months ago, and since then, the changes have come about, which actually increase the penalties which are imposed upon employers. So the latest situation is, for every employee who is found to belong to either of these categories, either here unlawfully or not allowed to take employment, the employer was liable to a penalty of £15,000 for a first offence, reduced to £10,000 for cooperating with the investigation, but going up to £20,000 for repeat offences. However, from the 13th of February this year, the penalties have tripled, and it's now £45,000 per employee for a first offence and £60,000 for repeat offences. although the faster payment option is still available. Now that reduces the full amount payable by 30%, but only for a first offence. It's not available for repeat offences. Now, one imagines that some employers will not be able to commit a second offence, having gone out of business after the fines imposed for the first offence. I mean, really, 45,000 per worker could easily bankrupt a business. Now, there is no liability at all if the employer has a statutory excuse. Now, with the penalty notice which is sent to the employer, there comes an objection form with which the employer can raise an objection to the penalty. And if he does that, well, if the objection succeeds and the penalty notice is withdrawn, great. But even if that doesn't happen, the faster payment option is still available, so he won't lose anything by objecting. However, if the objection form is rejected, there's still an option of appealing to the county court. But if he does that and fails, he can no longer get a reduction in payment. He has to pay the full whack. But more significantly, he'll have to pay the other side's costs, the Home Office costs. And if you remember what happened to one of the sub-postmasters in Mr. Banks versus the Home Office, he took the post office to court for a sum of £12,000, which the Horizon computer said was owing by him. And he was lumbered with £300,000 in legal costs when his appeal failed. So you go to court at your peril if you want to contest the penalty notice further. Now, what is the source of the authority to impose a penalty? Well, this is found at section 15, 1B3 of the Immigration, Asylum and Nationality Act 2006, which forbids an employer to employ an adult subject to immigration control if his leave to enter or remain is subject to a condition preventing him from accepting the employment. Of course, if you're here illegally in the first place, you're also caught, not quite by that part of the section. Now, I'm going to be talking about a situation which I myself am familiar with, which is where an employment agency had recruited a number of overseas students to work for care homes. Now, this is different when you're recruited by an employment agency for the purpose of applying for a health and care visa, and you'll then be working for the NHS or an outfit which is contracted to the NHS, as Sarah has just been telling us about. Now, these were international students and they were here on student visas. And one of the conditions for an overseas student is that, well, they now can only be employed if they're if they're at an A-rated educational sponsor. And of course, you would know that they can no longer be joined by dependents unless they're doing a PhD or a research-based MSc. Anyway, these students were mostly doing bachelor's degrees, some master's degrees, but they were all subject to the 20 hours per week working during the term time. Now, some people believe that you're not bound by this prohibition if you're studying for a PhD, but there's nothing to that effect in Appendix Student. And there is some case law going back to the old UK AIT 2008, which specifically found that PhD students are limited in the amount of work they can do during the term. Now, if you have a statutory excuse as an employer, you don't have to pay the penalty. And I'm just going to scroll on down a bit to see what you're supposed to do in order to have a statutory excuse. Now, the requirements are listed not exhaustively at section 15.3 of the 2006 Act. And this says that an employer is excused from paying a penalty if he shows that he complied with any prescribed requirements in relation to the employment. Oh, for fans of English grammar, I should mention that the 2006 Act may be one of the last, or maybe the last, Act of Parliament in which the male pronoun was used as the default, and it's since been replaced by they. Anyway, this says that, well, the excuses are listed at subsection 7. An order prescribing requirements for the purpose of subsection 3 may in particular require the production to an employer of a document of a specified description. And if we run on down these requirements from A to E, we'll find that they are all things that have to be done before the employer actually takes on an employee. It's mostly to do with providing things like passports, biometric residence permits, and so on, which show that the prospective employee is entitled to work in the UK. And it's only at E at the end that any action has to be taken after the employment begins. But in fact, what this means when it says action to be taken at specified intervals or on specified occasions during the course of employment, this will be because the employer is supposed to record when the residence permit comes to an end and has to be renewed. And at that point, he has to check whether the employee has renewed his residence permit in the UK. So these are the specified intervals. You'll see at the beginning of the second paragraph on this page that the Code of Practice in force in April 2022 specifies that an employer who receives a penalty notice may object and later appeal on 3 grounds, only one of which is relevant here. This is having a statutory excuse. There is now a new Code of Practice in force from the 13th of February 2024, and actually not as was previously thought, coming into force on the 22nd of January. It came in on the 13th of February, which is when the penalties went up as well. Now, anyway, the Code of Practice, including the new one, says that you have a statutory excuse, which means that you undertook a prescribed right to work check, if you have correctly carried out these checks before, and the underlining is in the original, before employment commences. So the emphasis all the time is on carrying out checks before the employment begins. And it goes on to say that the employer will not have a statutory excuse in 10 circumstances, which are then listed. And here we go. So it's only the last one of the 10 that can possibly affect an employer of students. And you won't have a defense if, in respect of a student who has a restricted right to work, you have not obtained and retained a copy of evidence setting out their term and vacation times, covering the duration of their period of study in the UK. Now, in this particular instance, the Home Office provided what they call a statement of case for each of the students who had been caught or had been found out working longer than 20 hours a week during the term. And in several of, or perhaps even most of those statements of case, there were other things that the students had done or not done, which actually did entitle the Home Office to find that they had worked in breach. Now, and that the employer had not done what was necessary to provide a statutory excuse. Now, apart from not recording when the term time or holiday time was for the student, there was another thing which they hadn't done, which was to copy both sides of the student's biometric residence permit. So photocopying one side wasn't good enough. And they also had to have taken a record of the term times and vacation times. And if they hadn't done either of those, they didn't have a statutory excuse. But there were some cases in which the only thing that the Home Office could use against the employer was that the employee had worked more than 20 hours a week during the term. And you might think, well, that's it, isn't it? That's good enough, surely, to mean that the employer has to pay a penalty. But I don't think it's that simple necessarily. Because in fact, in this situation, the recruitment agency was not in a position to find out, or at least not straight away, whether the students were working more than 20 hours a week, because they simply assigned the students to a particular care home. And as quite a large agency, there would be several care homes that they were providing employees for. And if we just scroll down a bit, you see where it says the code of practice says that a statutory excuse means you carried out document checks as required before employment commenced. Nothing at all is said about allowing students to work more than 20 hours a week after that. This was what the Home Office said in the statements of case. And, well, I wonder if this next sentence is quite correct. Infractions of the code of practice are matters of strict liability. So if the code is silent about something, one cannot have breached the code for doing that thing. I was reminded of one or two very well-known cases which went to the Supreme Court at the outset of the points-based system. Now, you may remember when that came in 2008, a lot of the requirements were not in the immigration rules, but in Home Office guidance. And people were being refused, not because they hadn't complied with the rules, but because they hadn't done something which was in the guidance. So this went to the Supreme Court, and in Alvey and Munir, it was held that if the Home Office wanted to rely on requirements which were mandatory, such that if you didn't fulfill those requirements, your application would be refused. Those requirements had to be in the immigration rules themselves and not in guidance. So the upshot was that all the guidance got shoved into the rules, and Phelan got swollen to about 3 times its previous size with all these new rules. Well, of course, this is to do with sponsor licenses and people who are entitled or not entitled to work. So it's nothing to do with the immigration rules themselves at all. But I wonder if something similar could be said about a code of practice. But I think it's well established that the code of practice for employers, or indeed for landlords who have to cope with the right to rent checks, whereas employers have right to work checks, it's so well established that maybe the principle in Alvi doesn't apply anyway. Now, the Home Office, when they were faced with the objection, they prayed in aid another subsection of Section 15 of the 2006 Act. The excuse in subsection 3 shall not apply to an employer who knew at any time during the period of employment that it was contrary to this section. Now, my argument would have been that this doesn't mean that if the employee starts working excess hours, and even if the employer finds out in the end, which in this case would have come to light because the students would have been billing the care home for hours in excess of 20 during term time, and that would have sooner or later come to the notice of the employment agency. But, I was hoping to argue that that if the applicant was thought to have a right to work, but the employer subsequently becomes aware that he is an overstayer and does nothing about it, then the employer loses his statutory excuse. But if the students simply start working more than 20 hours a week during term time, the employer does not incur any penalty, because the whole thing was based upon what is done before employment commences. Well, it would take a bold employer to argue this through to the county court with the risk of incurring stiff legal costs. So it may be some time before this argument gets an airing. But anyway, it was quite an eye-opener for me to the kind of thing that employers are up against with the penalties for employing people who don't have a right to work or who breach a condition by taking on the employment. So, and it's certainly a good way of screwing an awful lot of money out of employers. Well, now, something completely different. This is to do with the sole responsibility rule. And it's been around for donkey's years. In fact, it was in previous immigration rules like HC 251, which was superseded in 1994 by HC 395, which has been going ever since. And it was even around long before that. I think from when the immigration rules first came in 1972. Well, the leading authority is T.D. Yemen, and that was a case which was chaired at the Asylum and Immigration Tribunal by Mr. Ockleton, who you may know recently retired as vice president of the Upper Tribunal, and he'd held that post for many years. Now, I expect many of you will have done sole responsibility cases in your time, and it's usually the case that one parent has gone to the UK, usually in order to work and send money home, whereas the other parent has stayed behind um, and well, in fact, if the other parent is staying behind and looking after the child or children, that's very different from the sole responsibility situation, because two parents will have responsibility for any children. That's the norm. It's when the other parent, who hasn't gone to the UK, has disappeared, is not in the picture at all, but as far as the Home Office knows, is not dead. If the other parent was dead, then the sole responsibility rule wouldn't kick in either. If the other parent is still alive, or is thought to be alive, but is playing no part in the child's upbringing, then the parent who has moved to the UK has to, and if that parent wants to be joined by the child who is living abroad, that parent has to show that he has continued to exercise sole responsibility for the child. And somebody else will have been looking after the child, usually a relative, but it could be a family friend. And the issue will be whether the carer looking after the child has actually become someone who shares responsibility for the child with the other parents. And it can be quite difficult to show that the situation is not one of shared responsibility, but one where the relative or family friend who's got day-to-day care of the child is actually acting under the direction of the parent in the UK. So in that situation, the parent in the UK is exercising sole responsibility, but if the carer abroad has got to the point where that carer is making important decisions in the child's life, then it's likely that the carer is sharing responsibility with the other parent. And in that situation, the child is not going to get a visa to come to the UK for settlement with the remaining parent. So that's the situation. Now, what happens if, let's say, the father goes to the UK and his wife remains behind with their child, and the father sends money to the wife and child? This enables them to lead a comfortable life, which wouldn't have been possible if the father had remained in his own country and got a much less well-paid job. So it made economic sense for the father to come to this country and to send money back to his wife and child. Now, this situation may have been going on for a long time, and it may well be that in the course of time, the father goes back, maybe once a year. He goes back to visit his wife and child, and they actually produce more children. Now, if, having first come to the UK and having obtained indefinite leave to remain, the father in due course becomes naturalized as British, any children which are born to him by his wife will be automatically British by descent. So you could have the odd situation where the eldest child, who was born before the father moved to the UK and well before he became a British citizen, that child still has the nationality of the original nationality of his father and mother. And so it will have to be shown that the father has been exercising sole responsibility for that child if he is to come and join the father in the UK. It may well be to the child's advantage for that to happen once he gets to the age of, say, 15 or 16. If he comes to the UK, he will have immediate settled status, indefinite leave to enter, and in due course can become British himself and have a life in the UK, which may well be better than what would have been the case in the country of his birth. But you say, well, hang on a bit. Why can't the wife come and join her husband and take the children with her? What's wrong that she can't come? Well, there may be a situation where the wife can't get an English language certificate at level A1. Now, you might think that's rather unusual because that's the most basic English language test that there is in the Common European Framework for Languages. Level A1 is very, very basic English. And you might have thought that sooner or later, an adult who has no English at all would be able to learn enough to pass that test. But it can be that the wife doesn't reach that stage for a very long time. And in the meantime, the only way for the eldest child, who's not himself British, won't be able to join his father. There could be other children born subsequently after the father became British who are British by descent, and they can join the father. But that would leave the eldest child as a stranded sibling, as it were, the only sibling, and he and his mum would be stuck unless the father can prove that he's been exercising sole responsibility. Well, it's virtually impossible to do that when both parents are involved in the upbringing of the child. So let's scroll down a bit and you'll see Mr. Ockleton does indeed have something to say about this situation. And if you look at TD Yemen, there are a number of two parents cases which are analysed by Mr. Ockleton. And I give you the paragraph numbers. And there was only one, and that was at the Court of Session in Scotland, in which one parent was living in the same house as the child, but was divorced from the other parent and was playing so minuscule a role in the child's life that sole responsibility did repose with the parent in the UK. And that case is called Alagon. But the general rule is summarised by Mr. Ockleton as follows: wherever the parents are, if both parents are involved in the upbringing of the child, it will be exceptional that one of them will have sole responsibility. So there we are. And now for something different again. And this is curiously entitled, Paying Off the Afzal Debt. Now, Afzal was a case which came last year, not long ago, before the Supreme Court, and it's the most recent in a long line of cases before the senior courts to do with the 10-year rule. Whether you can obtain indefinite leave to remain by showing that you have spent a period of 10 continuous years in the United Kingdom with lawful leave. Now, this has already been summarized by Alex Paletska in the Free Movement blog. Well, no longer free now, you have to subscribe and pay, and also by Alex Papasoteriou, I think that's how you pronounce it, in the Richmond Chambers blog. And so this is my take on it. And I thought I'd put it in because for some reason I couldn't get my head round the rationale in this. But in fact, it's very simple, and you'll probably get it straight away if you've not got it already. But let's take a look at one particular case which I've come across, and we'll see how it works. Now, Mr. K, not the celebrated Mr. K, who will be performing at Bishopsgate. Those of you who are old enough may remember that from the Sergeant Pepper album. Anyway, Mr. K, an overstayer, was granted leave to remain for 2.5 years, beginning on the 1st of March 2014 and ending on the 1st of September 2016, 2.5 years, based on his relationship with a British partner and child. Now, provided he can meet the various requirements, making further applications in due course, after 10 years, he'll be eligible for indefinite leave. So that will be by the 1st of March 2024, 10 years after he first got leave as a spouse. Okay. Now, it's important that all the applications, the subsequent 3 applications which he makes for further leave and eventually indefinite leave, are made in time before his existing leave has run out. Of course, the Home Office also say you shouldn't apply more than 28 days before your leave is due to expire. But you've also got to be sure you don't leave it too late. Now, Mr. K falls at the first hurdle because he doesn't apply for further leave to remain until the 2nd of September 2016. So he's 1 day late, but he's nevertheless become an overstayer. But at this point in time, September 2016, the Home Office were operating outside the rules, a grace period of 28 days. And if you apply during that grace period after your leave has expired, that wouldn't be counted against you if subsequently your application was granted. So you wouldn't be treated as an overstayer, even though you actually had become one. Now, this 28-day grace period was reduced to 14 days from the 24th of November 2016. And it was actually put into the immigration rules at paragraph 39E. Okay, so you've got to apply for further leave within 14 days of the expiry of your previous leave. And then you can be granted further leave without being regarded as an overstayer. Now, this situation was considered by the Court of Appeal in the well-known case of Hoke, and Lord Justice Underhill, the Vice President of the Civil Division of the Court of Appeal, I think coined the term book-ended overstaying in contrast with open-ended overstaying. And the idea was that if between 2 periods when you're in the UK with leave, you were actually in the UK without leave, but you made an application within the 28-day or 14-day period after your previous leave had expired, and then you're granted further leave, that period in between is bookended, because on either end, you've got leave. In between, you've got no leave, but this period could be disregarded under paragraph 285B. Okay, so the wording was such that the whole period in between could be disregarded, and this was thought to mean that it was treated as though you had leave throughout that period, that bookended period. But that turns out to be not the case. And what the Supreme Court in Afzal have held, and let's see how this would work out for Mr. K. He made his application on the 2nd of September 2016 for further leave. That was out of time. He did not get further leave to remain until the 2nd of May 2017. So between the 2nd of September 2016 and the 2nd of May 2017, he doesn't actually have leave at all. However, this period is to be disregarded, and so he can still get indefinite leave, but not straight away at the end of a 10-year period after he first got leave. That would have been the 1st of September. Oh, sorry, the 1st of March 2024. That's when it would have come to an end, and he would have been eligible for indefinite leave, but he's not, because of the 8-month period in between September 2016 and May 2017. Now, those 8 months constitute what has been called the debt owed, it's now the Afzal debt. Certainly the Home Office have used that expression. That debt has to be paid off, and it's paid off by waiting until another 8 months have elapsed. So the 10-year point isn't reached on the 1st of March 2024, but it is reached on the 2nd of November 2024. That's when he's eligible for indefinite leave. Now, I'll finish with just a few highlights of HC 246. And I think these are things which will be something you can read for yourselves in your spare time. I was just rather amused. You'll see at the top. There used to be in India, certainly when I was there for a long time in 1974, there used to be wet states and dry states, and if you were moving around the continent, subcontinent, you could be in one location where alcohol was forbidden to be sold, but you could move to another location and you could get it. But I'd never heard of a wet lease and a dry lease before. Just coming down to the immigration health surcharge, this has been in force from the 6th of February, and the charge per annum is £1,035 for an adult, for most adults. And in fact, if you now are applying as a spouse to come to the UK, you're applying for entry clearance, to come to the UK for settlement, the combined cost of your application fee, it's gone up to more than £1,800, and the cost of your immigration health surcharge, which is now more than 2,500 for the 2.5 years, you're looking at nearly 3,500 for those two fees, the surcharge and the application fee. If you add on the fee for the tuberculosis certificate and your biometric appointment at the visa application centre, you're looking to shell out in excess of £3,500. Quite a whack. Now, there it ends, but let me just very quickly run through some important forthcoming events. You may already have these in your calendar, but coming up on the 11th of March, as Sarah has already told us, people who come under the health and care visa scheme will not be able to bring dependents with them. Those who are already here, however, can still be joined by dependents. Now that's on the 11th of March. On the 14th of March, the shortage occupation list, as recommended by the Migration Advisory Committee, will be replaced by the more restricted and oddly named immigration salary list. It's really doing the same job as the shortage occupation list, but it's more restricted. And then I think this is what many people have been fearing. On the 4th of April, the minimum salary for most skilled workers will rise from £26,200 to £38,700 per annum, but not, as Sarah told us, for those on the health and care visa. Now, finally, on the 11th of April, the financial requirement for the partner route of Appendix FM will be going up, well, not to 38,700 as was originally proposed, but to 29,000. But it's still a very large increase. Now, there is talk of Appendix FM finally joining many other bits of the immigration rules by being rewritten by the simplification of the rules team at the Home Office, SORT for short, the simplification of the rules team. They have hesitated to take the plunge and actually rewrite Appendix FM for for a very long time, and you can't blame them. But Appendix FM can't be rewritten any worse than it already is, so we can look forward to something easier to comprehend. I should think the very last thing to be tackled by the simplification team would be Appendix EU, which of course has frequently been commented on by the judiciary as well as by practitioners as being almost indecipherable. Well, I hope my talk hasn't been indecipherable, or my course notes, so do please read them at your leisure. And now it's time for me to announce that we are having a break, and we should be coming back in 10 minutes. So just time for a very quick cup of tea. I'll stop sharing my screen at this point, if I can. Here we are. So next on the list, we have Samina Iqbal, another of our favorite speakers. So I'll see you back in 10 minutes time. Bye-bye for now. Sorry, I was muted. Welcome back, everybody. And welcome to Samina Iqbal of Goldsmiths Chambers, and also an immigration judge, who is one of our regular speakers and is always very welcome here. So she's going to be talking to us about Article 8, conundrums for those excluded from the EUSS and the new minimum income requirement. So two very topical issues. And I think without further ado, over to you, Samina.
Thank you. Thank you, everyone. I'm just trying to make sure that I'm sharing my slides properly. Can you see those, Richard? Are they?
Yes, indeed, I can.
Okay, let me just make sure. I am playing them from the start. Here we go. That's better. Sorry, I couldn't see them properly. So good morning, everyone. Thanks, Richard. So this is Article 8 for those excluded from the EUSS scheme, but also more generally, just looking at Article 8 more widely. All used to it. I'm not going to teach anyone to suck eggs here, but we're all used to dealing with Article 8 cases with reference to partners, to spouses. But I think it's worth going over that in the context of those who are now applying, who may be partners of EU nationals who are excluded from the EU settlement scheme. We've all looked at extensively the EU settlement scheme. I think back in October, Sarah was looking at that, and we looked at durable partners, the Chelik cases. So I'm not going to give a very detailed overview of that, but just looking at how we can move forward from there with individuals who didn't qualify in those categories. I also want to look at adult dependent relatives. This is the new appendix ADR. You heard from Richard about the simplification of the rules. So this is one area where we're going to be seeing or looking at, which deals with that simplification. And then again, you heard Richard speaking about the minimum income requirement and the raised or the issue that the government's the amount to which it's going to be raised in the spring, well, coming up quite soon, what one would expect this year. So we'll look at that and look at how to deal with cases where the minimum income requirement has been raised and you might not be able to meet it, or your clients might not be able to meet it. So where are we with durable partners? Well, it was heard by the Court of Appeal. All the arguments were rejected. These were individuals who had applied as partners, durable partners, but they had not ever been granted any status under the EA regulations. And they were arguing that, so they never had a relevant document. So they were arguing that the partnership existed pre the specified date, but the courts found without the relevant document or having been granted status previously under the regulations, they could not benefit from the EU settlement scheme. So permission, I understood, was being sought from the Supreme Court, but that I've heard has sadly been refused. So what should we do moving on from there? What should we, as legal advisors, advise our clients to do? What's the next steps? I think we've already seen many individuals applying, making Article 8 applications under Appendix FM. So that is the obvious and next step. So what are we seeing, though, with reference to those applications? Well, generally, they're individuals who may not be here lawfully in the United Kingdom, so they can't meet the 5-year route if they have no lawful leave. That's the 5-year route as a partner under Appendix FM. So they look... they make the application, but it's considered with reference to the 10-year route. And they have to meet the suitability requirements, which they generally can. Financial requirements, again, generally they can. The English language requirements. But the difficulty comes with reference to the eligibility requirements, where they may meet the relationship requirement, but not the immigration requirement. And in those circumstances, in fact, if any aspect of the requirements are not met, they would look to EX1 of Appendix FM, which creates an exception for in-country applications to be made. again, everyone's going to be very familiar with EX.1. I don't want to spend too much time with this. It mirrors 117B of the Nationality Immigration Act 2000 and I want to say I can't remember, but yeah, so it's the Nationality Immigration Act, I think 2012. I don't know why I'm saying 2012, but I'll get back to you on that. But it's the one which we all are very familiar with. And individuals would have to, looking at EX.1, individuals are going to have to demonstrate that they are insurmountable obstacles to the family life with the partner continuing outside the United Kingdom. That is the key to an application succeeding under Appendix FM or EX.1, where an individual cannot meet a particular requirement. I am just highlighting that because we often forget that we're still looking at the rules. We're still looking at it, and we're looking at a very specific requirement for insurmountable obstacles with reference to family life with the partner outside the United Kingdom. So we're not looking at one particular individual, we're looking at the collective, both partners, the sponsor, but the appellant themselves as well. And when you look at that, the definition for what an insurmountable obstacle is can be found at EX.2. And it's quite clear that there are very significant difficulties which will be faced by the partner living together outside, which they cannot overcome or would entail very serious hardship in relation to either the applicant or the partner outside the United Kingdom. The place to look in relation to insurmountable obstacles is also the guidance. And as I said, I don't want to spend too much time in relation to this aspect because we're all very familiar with it. But how are we looking at it with reference to those who haven't succeeded under the EU settlement scheme and individuals or partners? The sponsor is an EU national with settled status or pre-settled status. Again, this is something that has been covered previously in a previous talk. We're looking at individuals here who've qualified, the sponsor themselves who've qualified under Appendix EU. They have settled status here because they've been here for a period of 5 consecutive years, or they have pre-settled status or been granted pre-settled status here. Well, how is this relevant to the question of insurmountable obstacles? Well, what they're asking by reference to the test under insurmountable obstacles is that one of the partners goes to live with the appellant back in their home country. What does that mean, though, in terms of their status here in the United Kingdom? They're being asked to essentially live outside. They hold indefinite leave to remain or a lesser period of pre-settled status, so they haven't yet acquired indefinite leave to remain. But what happens in relation to that if they're not present in the United Kingdom for a continuous qualifying period, then that leave that they have been granted can lapse, and it can lapse in the case of an individual who has settled status if they're outside of the United Kingdom for more than 5 years. Not so much of a difficulty if you've got a 5-year period to travel back in and out of the country. But what if you're someone who has pre-settled status, you're the EU national, and you're being told there are no insurmountable obstacles to your family life continuing outside the United Kingdom. You have pre-settled status to stay in the United Kingdom. Is that an insurmountable obstacle? Well, we need to look at that a little bit more carefully, and I think it's worth certainly arguing that it's a legal obstacle, because this individual who's being told to establish Sorry, Richard, is everything okay?
I'm sorry to be popping up right in the middle of what you're saying, Samina, but actually there seems to be a problem with the slides. They can be seen on the left-hand side of the screen in a list going down, but I think you want them larger and in the middle of the screen, don't you? So we can see in the middle your very first slide, Article 8 conundrums, etc., the title. And then on the left-hand side, you've got a succession of slides going from top to bottom, but I guess they should really be filling, I mean, each slide should be much larger on the screen, shouldn't it?
So what I'll do is I'll stop the sharing. I'll try and share again.
Okay, fine. Thank you.
Is that any better?
Yes.
Thank you. I don't know what happened there. Slight technical difficulty, and sorry, everyone. But yes, coming back to the continuity of residence in EX.1. So just recapping, you're looking at someone who has to demonstrate there are insurmountable obstacles to their family life continuing outside the United Kingdom. Is it enough to say that they will lose their rights under that they've been granted? The sponsor will lose their rights that they've been granted to live in the United Kingdom by reference to the EU settlement scheme and the withdrawal agreement, which guaranteed certain rights. Now, it's a slightly perhaps difficult or nuanced argument to make, but it's certainly worth making in relation to these kinds of cases because it certainly is an obstacle to family life continuing outside the United Kingdom. Now, that so that's just to recap on EX.1 there. I want to move on to the adult dependent relatives. As I said, it's an attempt here to simplify the rules with reference to adult dependent relatives. Those of you who have been in practice for a very long period of time will remember paragraph 317, which is where it all started, where you could bring in dependents to join you from abroad. It then moved to Appendix FM and E-ECDR, which is dependent relatives. The test hasn't changed essentially, but what it does do under Appendix ADR is simplify our consideration of the elements that need to be met with reference to an adult dependent relative. This was brought in on the 1st of June 2023. And if I take us through it and recap what we need to demonstrate, I think it would be quite helpful. So in the first instance, we look at 4.1. It provides us with the scope, ADR 4.1 of the rules, more generally provides us with the scope of those who can be an adult dependent relative. It's restricted to our standard nuclear families, parents, grandparents, siblings, and children. And then looking at 4.2, it's those individuals who can sponsor those who meet the ADR category. And those are generally British citizens or anyone with limited with leave under Appendix EU, so that there is inclusive of those kinds of individuals, and then persons with refugee leave or humanitarian protection status. So that's 4.2 and worth looking at. What I wanted to focus on was the dependency requirements for adult dependent relatives. And again, this may be a recap for many of you, but you'll see the main requirements here are set out at ADR 5.1. First of all, is looking at the an applicant must, as a result of age, illness, or disability, require long-term personal care for their everyday tasks. And you must break it down. When you're looking at applications in this context, it's very helpful to break down each stage. And I know that many individuals already do that. But first of all, focusing on the question of long-term personal care and performing everyday tasks, what we need to look at is the long-term personal care needs to be something more than just a temporary thing that's happened, you know, for the last month. It's got to be something that's long-term, it's ongoing. And with reference to everyday tasks, you're looking at those things which include daily living, daily life, that's washing, bathing, feeding, cleaning. It's not exclusive, so you're not looking at simply all those different tasks, but you can show different elements of it. And it includes going out and even companionship. I think that the guidance, we've always argued companionship, isolations, psychological isolation, but I think the guidance now is a little bit wider in encompassing that as part of its definition. So it's definitely worth reverting back, and I have highlighted some of the links that I have in here are interactive, so you can refer back to those different links, and I have in one of the next slides set out the guidance for you, because it's quite helpful to go back when you are making these kinds of applications. So along that route, following on from there, we want to look at ADR 5.3. When you look at 5.3, you're looking at what kind of long-term care is needed, and you must go on to explain the level of care that is required. And again here, the Home Office guidance is helpful, because you're looking at the specific needs of an individual, and it highlights, as I say, the emotional and psychological needs, which is one stop beyond when we usually explain that they've got a physical carer, but it may be beyond that. And some case law, which I have referred to a little bit later in one of the slides, it's a new slide, so I will make that available to everyone, which is the Britsitz case. Which hopefully many of you have heard of, but it does support the fact that emotional support is going to be required in such or emotional support is something that can satisfy this part of the rules. The next part to look at when you're looking at dependency requirements is the ADR 5.3. Where you are looking at an application, the applicant themselves is unable to obtain the required level of care in the country where they're living, even with the financial help of the sponsor, because either the care is not available or that there's no other person who can reasonably provide it. So the part to look at in this is that whether or not, first of all, of course, if the care is not available, but looking at whether it can be reasonably provided. And the key is in the word reasonably and the concept of reasonableness. You can do a lot of heavy lifting here. You can put in a lot of evidence here to support these kinds of applications. But often the Home Office argues that there are institutions that can provide the care that's needed. But we know what we could do is front load it by looking at whether or not it's reasonable for this individual to be provided this kind of care by this institution. Does it satisfy all the other requirements of the emotional and psychological needs of the individual? So it's collectively looking at different parts of it, providing evidence here. And your focus when you're looking at adult dependent relative applications should be with reference to whether or not that care can be reasonably provided. Of course, we always revert to whether or not the care is affordable, if there's free local care. But if you're able to demonstrate at 5.3a that the care is not available or it's not reasonable, or it can't be reasonably provided, then you don't even need to get to whether or not it's affordable. So it's taking each stage of the rules as they come when you're looking at these kinds of applications. Remember, I think one of the things that we don't provide enough of is medical evidence and a full accounting of an individual's medical background, things that the ailments they've been suffering, and how they appear to be coping through those their illnesses or the support that they require with what they have in their country. So it's really worth getting a very good medical report and thinking about where you get that medical report from. Although you often would look to the country that they're in, it may well be that you ask someone to look at it here with reference to all their medical records and provide a full report in relation to that. And that is where most applications do fall down, is with reference to this dependency requirements. But let's not forget, as per the next slide, the financial requirements. In these applications, I won't go into much detail, but you also must always refer to the financial requirements and whether or not you can provide, or whether or not an individual can provide adequate maintenance accommodation without access to public funds. This is looking back at the old test, as it were, and what individuals are asked to do in these circumstances is to sign a maintenance undertaking. That's at 6.4, and it's usually for a period of 5 years and until they're granted settlement. And not to forget at 6.5 that the government can seek to recover public funds that an applicant receives whilst the maintenance undertaking is active. So that's just something to remember and remind ourselves about. And what I've done is highlighted here the guidance on Appendix FM and adult dependent relatives of adequate maintenance and accommodation. I think we all get caught up with the threshold requirements, but here we're looking back at the old test of whether they can be adequately maintained and accommodated without recourse to public funds, and that's by reference to looking at income support levels. What I've done here is highlighted again the RightsNet website, which is an external website which provides us with all the income support levels, which we can refer back to when preparing these kinds of applications. And it's worth highlighting how you meet those financial requirements. But all is not lost if you can't meet those very, very strict test. The fallback has always been looking at Article 8, even for adult dependent relatives, and it is provided for within the ADR appendix itself at 7.1. You'll see that it provides there that if you can't meet the suitability eligibility requirements, that you can look to whether or not it would result in unjustifiably harsh consequences for an applicant or their family member. So as I say, it's been no material change to that part of the rules, and it's just a reminder that it's worth front-loading the application, both with reference to the rules themselves and the requirements under the rules, but in the alternative also referring to whether or not what the unjustifiably harsh consequences are. With reference to Article 8, as I said, and I said I would highlight the guidance there. It's again an interactive link, so you can click on that and be taken straight to the guidance. The relevant one at the moment is the August 23 guidance. This is the new slide I referred to in some of the case law, because it's relevant to look at that with reference to the rules, you're not looking at whether there is family life, but with reference to Article 8, there will always be the consideration of whether or not there is family life between individuals who are adult relatives, and that could be parents, grandparents, but also adult siblings. I think we all know the lines of various cases of Kugathas, and there are a few others. But in the context of the adult dependent relatives, I thought it's important to just flag a few of the more common cases. The case here of the Britsits of 2017, heard by the Court of Appeal, made quite clear that the relationship, it will be fact dependent, everything will be fact dependent. So you need to front load the application as to the nature of the relationship. Here, it will depend on all the facts as to the relationship between the parent and the adult child and its history. So how many visits that child, the adult child, has been making to the parents over the years, what's the frequency of that visit, those visits, especially in more recent times when they say things might have changed, and that's why they're making this application under the rules or under Article 8. You'll see there's an older case here, A.W. Khan, that's the ECTHR. And again, that says that there'll be no family life unless they can demonstrate additional elements of dependence that can include financial dependency. And that's what ZB Pakistan said, so it's worth having that in your armory as well. And then in the context of adult siblings, you can look at the case of Singh, and as I said, there was also Kugathas, but Singh is a case of the Court of Appeal where it had adult children and parents, but also looking at, even if a child's just turned over the age of 18, there is a number of authorities which talk about there being no bright line just because they've turned over the age of 18. They might be still supported fully by the family, dependent on the family. They might well be living at university, but the university fees are being paid by the parents in full. So all sorts of things to consider when you're front loading any applications with reference to the adult dependent relatives, either abroad and sometimes here in the United Kingdom. And as the courts have repeated over and over, it's a very fact specific and highly sensitive exercise. So it helps to have all relevant evidence at the outset of an application with reference to these kinds of applications. And just for the sake of completeness, I would add here that if an applicant fails under suitability grounds because, or they could fail under suitability grounds because they have an unpaid litigation debt or involvement in a sham marriage, or they could be refused with reference to another element, but this could result in a refusal under Article 8. So it's worth keeping in mind if they've previously been in the United Kingdom for whatever reason, whether checking with applicants whether or not there are any other grounds or any unpaid debts, because we're seeing this more and more, certainly. So that's just something to keep in mind. And that takes me to the next aspect of the talk, and that's the minimum income threshold. You heard earlier Richard talking about the increase to that. We all know it's 18,600, and I kind of posed the question here because there's been some confusion over what actually the minimum income threshold is going to be. Is it 29,000, 38,700? Well, no doubt we were all quite shocked. For those of you who thought it was 38,700, the government did wheel back slightly from that and saying what we'll do is we will have incremental increases. So in spring of 2024, that's imminent, we're going to raise it to 29,000. And after that, it will be increased later in 2024, so again later this year at some point, to 34,500, and eventually in early 2025 to that 38,700. Now, where are they getting those figures from? It seems as though there's a move to make it consistent with the work permit thresholds that we're seeing. So the general skilled worker threshold, from what I understand, is at 38,700. So it's making it consistent with that. It's quite a difficult or a high threshold to meet, and that's what we know from the applications or the individuals that we're generally dealing with on a day-to-day basis when the appeals come to us. What it will do is it will no longer have individuals, the only advantage to, I suppose, is that individuals will no longer have to demonstrate a separate child element to the minimum income threshold. And this is to ensure that British nationals are not being treated less favourably than migrants who perhaps are or were, because they're not going to be allowed to bring their dependents anymore, were able to meet the general skilled worker threshold as a flat rate, regardless of any child being sponsored. So a change on both ends, but an advantage for children who are a party to any application. Now, what are kind of the looking at the effect of it? Good news if you already have a family visa, spouse visa, civil partner visa, or an unmarried partner visa, and you're already on the partner 5-year partner route, and you're simply applying for an extension, you will continue, it won't be retrospective, so you'll continue to be considered with reference to the 18,600 threshold. So that's the first part of it, or first part of good news with reference to those kinds of applications. Also, if you've applied for a family visa before the raise to the threshold, then again, you are going to remain under that threshold route, the 18,600 route. And this also includes fiancé visas. If you've made that application before the threshold route, again, your route under the 18,600. If you're a first-time family visa, making a first-time family visa application after the increase to the threshold, 29,000 applies. I don't know what happens if you're on that route of 29,000, you've got to show that. And then there's the increase to the 35,000 or 34,500 or the 38,700, whether that's going to be retrospective. So that will be interesting to see once this threshold comes in, and then the next threshold, whether individuals continue to remain under this route of 29,000. I think it makes sense that they do. If they don't, then I think that it's worth looking at in terms of whether or not a challenge can be brought. But that's a long way away, a long way down this particular road. Now, bad news, unfortunately, for those in the United Kingdom on any other route, if they're in a student route or any other route, worker route, if they wish to switch into a partner route after the threshold has increased, then they're going to be subject to that 29,000 as well. Well, what can you do and what can you advise? There are some exceptions and exemptions. The first, of course, apply before the new minimum income requirement is brought in. And if you're unable to, then what exceptions and exemptions apply to you? Well, I've already mentioned previously EX.1 and insurmountable obstacles, and that's with reference to not being able to meet the financial threshold requirement under Appendix FM. You then look to the 10-year route and whether or not once you work your way down the relevant rules, EX.1 applies and there are insurmountable obstacles. Again, don't forget front-loading that part of the application. That's that slide there. Exemptions. An exemption is only applicable when an individual is on a recipient, or the sponsors a recipient of a certain benefit. And Appendix 12, Paragraph 12 of Appendix FMSE provides an overview of the different benefits that you might be able to rely on as part of your exemption to the minimum income threshold. And then you look at the old test of maintenance and accommodation without recourse to public funds. I'm referring you to the guidance there. It's quite helpful on that as well. And then you look back at the level using the external website on RightsNet as to what they might have to meet and what they have to show. It's the guidance is quite helpful because they have these helpful tables where you can calculate actually how much the maintenance accommodation or maintenance an individual would have to demonstrate by reference to any kind of benefits that they're in receipt of. And then another way forward is to look at GEN 3.1. It's looking at if you cannot meet third party or prospective earnings, you don't avoid the minimum income threshold. What you do is you look for wider range of sources as set out by reference to paragraph 21A2 of Appendix FMSE. I've set out both for you. And what you're looking at there is other ways in which to meet the threshold, which are not through a sponsor's income in itself. You're looking at whether or not they have, and this is an introduction back into what we would look at previously under the old rules pre-Appendix FM was looking at third-party support, but the rules are actually now providing for it. But it has to be credible guarantee of sustainable financial support to the applicant or their partner from a third party. So third party support. How do you provide that? You provide bank statements from individuals. You provide their, I've gone to the next slide. You provide their, I seem to have gone 2 slides forward. You provide their bank statements, their earnings for 6 months, and so on. And then schedules. I think everyone forgets about this, but provide a schedule of income and expenses of the third party. You need to know what their finances look like, and therefore convincing either the Home Office when they're looking at the application or a judge on appeal that they are credible in being able to provide this financial support in the long term. And then you're looking at prospective earnings. Again, this is something we used to see pre-Appendix FM, prospective earnings from a sustainable employment or self-employment. So if someone's saying, and that can be the applicant or their partner, if an applicant is being offered employment during the course of the application, they want to put forward that they're going to be employed, it's got to be a credible offer. It's got to be in line with their skill set. And we often used to see a family member who perhaps owns a business would offer them employment. But actually then what you have to do is show that that family member or that business is in need of an individual or the skills or the help that that individual or that applicant is going to be able to give. So it has to be front loaded. You can't just assert it, provide the evidence to support that third party, the prospective earnings. And then the third is any other resource. So anything else, credible, reliable source of income or funds available to them at the date of application, or which will become available to them. So that again it could well be savings from somewhere or someone, and calculating whether or not it would then meet the financial requirements by reference to Appendix FM SE. So always go back to the sources, Appendix FM SE, which is specified evidence, and Appendix FM itself, to see what can and cannot be provided. And again, here with reference to these kinds of applications, the guidance is always really helpful. The Home Office guidance, which I've already flagged, in providing an overview as to what they will consider. It doesn't mean it's exhaustive. You can provide something else as long as it's properly explained and properly evidenced. But it can be helpful to provide us with some guidance as to what we need to do or what we need to provide. And that takes me through to, so that was GEN 3.1. GEN 3.2 of Appendix FM is more general. This is the one that I think that we see more widely. It's where the refusal would constitute a breach of an individual's right to family and private life under Article 8 of the ECHR. It chimes with what we've seen under Appendix ADR, and that was 7.1. So again, it's the use, this is providing simplification and consistency across the board of different applications that are being made in the family life routes. So it's just interesting to note here again, at 2, it says, with reference to the refusal, it would result in unjustifiably harsh consequences for the applicant or their partner or relevant child, or another family member whose Article 8 rights, it is evident from the information, would be affected by a decision to refuse the application. Now, I just wanted to focus on this part of it because I think we all do forget that this part actually relates to a whole host of individuals. So this is not only the applicant and their partner, it's a relevant child or another family member. So it's Article 8 rights, and it's looking at or endorsing what Bieku Betts said, and I think that was the Supreme Court, what it said in relation to looking at Article 8 in the context of third-party rights. And when you're looking at paragraph GN 3.2, it does exactly that. It looks at everyone who is connected to that family unit. And this is where we need to think a little bit creatively when we're looking at these applications, but mention all the individuals, the child, the partner, but they may be an elderly parent, or other children of either partner or the applicant themselves, who are affected by the refusal of the application. So look wider and provide the evidence again to support any such application. When you're looking at this aspect, I've just highlighted the case of our Agiako in relation to Article 8 rights, because what the court said is that we must give due weight to the Secretary of State's policy expressed in the rules about public interest in immigration control being outweighed only where there are insurmountable or exceptional circumstances as defined. So that ties in with the unjustifiably harsh consequences. I think that the terminology is all interchangeable when you're looking at these kinds of applications, that you can outweigh, as long as you provide the evidence insofar as the harsh consequences, exceptional circumstances, or insurmountable obstacles, then you can outweigh the public interest. And what I do want to look at in the last slide is relevant factors. And I think, again, we all forget to outline what are the relevant factors with reference to the Home Office's own guidance. go back to the guidance, go back to these relevant pages at 65, 67, but it gives you a list of how these individual factors might affect an application. What are the best interests of a relevant child? The ability to lawfully remain in or enter another country. It may not provide for individuals to go and live in another country. So the spouse, where they say there are no insurmountable obstacles to family life continuing outside the United Kingdom, that country may not allow individuals of a certain nationality in their country. They may not grant them entry clearance. They may not grant them long-term visas, long-term spousal visas. For whatever reason, there are legal obstacles, so always explore those with your clients. And then the nature and extent of family relationships, and you're looking at other relationships that the sponsor themselves might have in the United Kingdom. I think I've already flagged that. And then where they might be separated from a child who may not be living with them, or a biological child who may be an adult now, but still requires their assistance. And then, of course, the impact on all of those if the application is refused. So separation, impact on them. We all are well aware of the cultural barriers to relocation. You know, there could be language barriers, cultural barriers, individuals never traveled there before, never traveled out of the United Kingdom before. Explore them all and set them out. And if you have to, you can set out all these as headings to address them in term, and that would strengthen any application that you do make in relation to family life. And then also, one which is often forgotten is the impact of mental and physical disability of a serious illness which requires ongoing medical treatment. And again, that could be with reference to any of the individuals that I've highlighted already that will be affected by the application. And it doesn't have to be at that Article 3 threshold. It doesn't have to be at a certain threshold at all. You're just putting it in the mix with all the other factors that you're presenting that make the circumstances unjustifiably harsh for these individuals. Again, another important one is the security situation in another country. It may well be, may well not be at the threshold of an asylum claim or anything else, or even humanitarian protection, but it may be something that an individual who's lived here all their life in security, and if there is some instability in the country in which they're being required to relocate to, then highlight it, highlight their individual circumstances, their what they are used to compare to what they might be asked to face if they return to a country where there is some instability. I've already dealt with the immigration status of an individual and whether there are legal obstacles to that. But again, cumulatively, the factors need to be considered together. So you would highlight all those which are applicable and refer to them as being cumulative to an Article 8 application and why it might be successful, or why it ought to be granted. And so with that, I think it brings me to the end of my talk in relation to Article 8 conundrums. I've covered 3 different areas, some not in that much detail, because I know that we're all very used to looking at Article 8 applications, but I just thought it was worth relevant reminders in the context of those applications that we're seeing now that come forward from EU nationals who weren't able to, their family members weren't able to meet the EU settlement scheme. And I think I've finished maybe 5 minutes earlier. I'm going to stop sharing for now, and I'll see whether or not there are any questions at this stage. Or Richard, I can
Oh,
add.
sorry for butting in, but yes, I've been having a look at the Q&A box myself, and there are some questions for you if you've got time to answer one or two of them now. But of course, we've also got the panel session this afternoon.
Yeah.
But if you do think you'd like to have a look at one or two questions before the time runs out for your slot.
Okay, so yeah, because I have 5 minutes, I'll use
Right,
that.
you are. Oh, well, I'll leave you to it then for another 5 minutes. Thank you very much.
So it's the first question, I'm going backwards, is it says, I have a question regarding the changes on 11th of April. 18,600 threshold will apply to those already on the 5-year route. Will there still be an additional amount for the children, or will they be dropped? I think it's I think that they will remain on the route that they've already started on, the 18,600 plus the whatever they would have to have shown for the child. But it's worth putting forward or arguing that, and there's no reason why you shouldn't, if that given the children, the amount for children is being dropped in the future, why not for this particular application? But I think do that as an alternative rather than your first port of call. Show that you can meet the threshold. If there are some particular difficulties why it can't be met, then refer back to the fact that that's now being lifted in the future. And I think the reason why it is being lifted is because the amount is now increased. So, but also it brings it in line with other elements when dealing with children and the high fees that we see being charged for various applications that have to be made with reference to children. So I hope that answers that. And then I'm looking at TMC solicitors. It says, in one of our ADR cases, the Home Office did not accept relationships from an official family registration certificate. A British citizen's sister was sponsoring her mentally unwell brother. What would you advise in such cases? What should we provide to establish the relationship with the sponsor? I mean, ultimately, DNA evidence, but sometimes that can be quite costly for individuals. But why not other evidence of other individuals? They often have certain municipalities in certain areas, any other individuals who know those, the applicant and the sponsor. And I'm talking about doctors, I'm talking about anyone else they would have depended on in an official capacity. But there's nothing to stop you from getting the neighbours or other relatives to provide that evidence as well. So it's worth kind of exploring different kinds of evidence and putting that together if you can't get the DNA evidence. But the DNA evidence is hopefully going to be determinative of that. So I think, yeah, I've got time for some more questions. And then I've got Tajamal Butt, and he says, I wonder if you can share your thoughts on the following. What is the best available option for a non-EEA national spouse living abroad to join her EEA national husband with pre-settled status when their relationship developed post 31st December and they got married in July 2023. They've been living and working in the UK. EA sponsor has been living and working since 2019. Can he apply under the family permit under EUSS or instead Appendix FM? I think it sounds like the relationships after the specified date, the marriage is after the specified date. And so the EA national now has to rely on domestic provisions with reference to any applications that he wants to make for his family members. And I think the answer is, and I can double check that, is Appendix FM. We can check later in the panel session. double check that with Sarah as well. But yeah, my view is that it's likely to be Appendix FM. Yeah, and hopefully he can meet the thresholds for finances and so on. Yeah, I'm just wondering whether or not you if you'd wanted to, you could make it as a secondary application, but not your primary education application under the family permit under EUSS. But I don't think they would qualify, so it may just fall aside. And even if they're granted leave, then that may be cancelled at some point in the future. So I think it's going to be safer under Appendix FM, but we can double check that at a later date. Sorry, in the panel session, sorry. And another question, and I think this will be my last one. We have an applicant who is under EUSS, his wife has joined him under EUSS, both have pre-settled status. The child was born outside the United Kingdom after the cutoff date. We made an application under Appendix FM. They refused it, stating parents go live with the child. Client submitted an EUSS family permit application from outside the UK, which was also refused. Where did the children of EUSS stand in such cases? Now, my understanding is if they've both got status, EUSS, yeah, both the husband and wife have got EUSS status, then even if the child is born outside of after the specified date and so on, they still fall to be considered. That was one of the exceptions from what I can remember from one of the very first talks that we gave on EUSS. That was an exception to the requirement to have had the relationship prior to the specified date. So that's worth looking at. I'll see if I can dig that up during the panel session and pop that in again. Pop that in the chat, and you're more than welcome to ask that again. But I think that they should qualify under the EUSS family permit route. I'll double check that for you though, see if I can find anything useful. Okay, and that brings me exactly up to 12:30 and the end of my session. Other questions, hopefully, we can get to during the course of the panel session later on, where I'll be back.
Well, thank you very much indeed, Samina. That was a fascinating talk, and you ranged very widely. I think you're absolutely right in answering that last question. It's another example of Home Office caseworkers not understanding Appendix EU. It's so complicated that they get it wrong. So
Yeah.
it's not surprising if we have difficulty ourselves. But anyway, it's going to be a lively session in the panel this afternoon, I'm sure, and there'll be lots of things to talk about. Now, the fact that the panel discussion is not on till after 3 o'clock means that people have to come back this afternoon, so they can't get off as early as they might have hoped if they want to catch the panel. But we'll see you then after 3 o'clock for that session. Thank you. Now, next on the agenda, I hope, yes, he is there, Nishan Paramjorthy, head of his chambers, and another regular speaker at these webinars, and you're very welcome again, Nishan. Excuse me. Now, you'll be talking about the Illegal Migration Bill, or Act, as it now is, which I've studiously avoided getting into, so I'm looking forward to getting some insights into it now. What does it really mean? We're soon going to find out. Thank you, Nishan.
Right. Shall I just begin, Richard? Can you hear me loud and clear?
Yes, indeed. I can hear you loud and clear. So
right.
Please go ahead. Thank you.
Right. Thank you. Good afternoon, everyone. Sorry about the shambolic joining in. I'm talking about probably the most contentious topic of the moment, which is this new Illegal Migration Act. Now, my notes, I'm sorry, are slightly dated in that they speak of the impending judgment in respect of Rwanda. But as we know, Rwanda was knocked back before Christmas, and Rishi Sunak, in his infinite wisdom, and whoever it is, is it Cleverly now, who's the Home Secretary, who's not so clever, is it intending to rush through some sort of reassurance from Rwanda so that they can undermine the decision of very experienced judges, both at the Court of Appeal and the Supreme Court. Now, talking to you about the Illegal Migration Act, we all know essentially that it is a politicized state of affairs. It was brought in to deal with what they said is issues with crossings, to stop the boats. It was announced on the 7th of March 2023, and its overall ambit was to remove those who enter the UK via unauthorized routes, or in essence, to remove those who could be sent back to a safe country, Rwanda. Now, let me come in at this point. I'm not sure if you're aware, but a Freedom of Information request was done, and it was established that some Rwandan nationals had been granted asylum by the Home Office on the basis that due to their political affiliation, there was an insufficiency of protection, and that the state was both unwilling and unable to provide a sufficiency of protection and just merely didn't have the measures in place. But there's obviously a substantial tension between the Home Office saying that the Illegal Migration Act and removals to Rwanda are something that can efficiently and meritoriously be undertaken. So going back to the Migration Act, the idea is to restrict, in my view, access to justice, because you're going to be detained if you come in illegally in that manner, access to being released on bail, and also to really apply for judicial review if you think that you can challenge the Home Office decision that's been put before you. I'll come to what the court's jurisdiction is going to be in respect of the Illegal Migration Act shortly. But it is essentially engineered to disregard, in most cases, asylum or human rights claims made by asylum seekers. It is designed to widen the scope of the powers of detention for the purposes of removing people, and possibly also allowing for the first time the detention of children. I personally consider that there is going to be a lot of child assessment disputes. I personally consider that there's going to be substantial challenges overall to the incompatibility with the Refugee Convention and the European Court of Human Rights and their overall stance on this. My view is that it really fundamentally goes against the spirit of the UNHCR handbook. The UNHCR handbook, if we can go back all those years ago, tells us that we're able to use whatever means possible in order to preserve life and to evade persecution. That means entering illegally. But if we rhetorically ask, well, are we now going to suggest that those who manage to instruct illegal persons traffickers, who manage to get people valid visas to come in, are we suggesting that their claims should be heard over those who simply don't have those sort of means, who are fleeing war-torn countries? We hear very little about what's going on in Yemen. We hear very little about other parts of the world where there are ongoing potential serious human rights atrocities, and the fact that those people may not have substantial funds to pay for traffickers to come in. So that's another view that we just need to look at as a whole. It's a very ill-thought piece of legislation. I mean, the purpose of the Act is to really reduce the oversight of courts. It's going to organically result in substantial litigation. It also calls into question where those who are in detention will be held and how they will access legal advice. Tens of thousands of people could be detained indefinitely, and that will be at extensive cost. My view is that the Act is really not workable on its own terms, and that's why there are difficulties. It does call into question our commitment to the Refugee Convention, which has long underpinned our position as a human rights and refugee-sensitive country, at least. So what is the bill? It was introduced to Parliament to stop people coming in on the boats through the English Channel. The plan is, the design, the spirit of it is, that anyone who arrives irregularly into the UK, whatever that means, will have their asylum claim deemed inadmissible. The Home Office won't even consider the merits. They could be detained indefinitely and then removed either to their own country or to a glorious safe country, such as, third country rather, such as Rwanda. The stated aim of the Act is to prevent and deter unlawful migration. And it's under this guise that, unfortunately, there are people who have died in the crossings. We know about that. I very recently represented a young Albanian lady who crossed over with her 4-year-old son. She was a victim of trafficking. Unfortunately, her son had seen someone die on the boat on the way over. It was the only means that she had available in order to preserve the life that she had and that of her son. If she had entered after the cut-off period of the Migration Act, the claim wouldn't have even been considered, even if she'd raised trafficking or trafficking or modern slavery grounds. The Home Office saw the merits of her case and granted her asylum after an interview. But when I look at that example, it's fairly damning, because the idea is to deter unlawful migration. This was one of the quickest acts to whiz through Parliament, and it was debated for circa, I think, 5 months before it was passed in July of last year. Now, what duty does it place on the Home Secretary? The duty it places on the Home Secretary is to remove anyone arriving irregularly to the UK, including those arriving by small boat, other forms of transport, I guess a lorry, etc., and that they should be swiftly removed to their home country or Rwanda. The duty does not, however, apply to unaccompanied children. But we can take no solace in that. The Home Secretary will only be required to remove them after they're 18. So anyone, therefore, who crosses in a small boat or another irregular means after the 20th of July will not have their claim heard at all. The government intends to detain and swiftly remove them. Now, there's no legal duty on the Home Secretary to detain people. It's only a power to do so. And people can only be removed to their home country if they're from one of 32 countries, which are the EU 27 member states: Iceland, Liechtenstein, Norway, Switzerland, or Albania. Anyone who falls outside of that catch-all can be removed to glorious Rwanda. Now, what's troubling is that the government has signed a migration and economic development partnership with Rwanda. I think it was the tune of £120 million. And as we know, the plan faced challenges and in the end was knocked back, but that's looking to be revised by the government with so-called reassurances from the Rwandan authorities. Now, who's been affected by the Illegal Migration Act so far? It says in short, nobody. That's not quite true, actually. I've received some letters, even after clients have been interviewed, to say that no decision will be taken on their asylum case until they have reviewed whether the case falls within the catch-all of the Illegal Migration Act. So in other words, legally they don't have to make a decision ultimately, and they can decide whether there is a Rwanda referral that's required in the circumstances. Now, on the 28th of September last year, certain provisions came into force. It gives the Home Secretary more power to determine what's a reasonable period of detention. And the provision goes much further than ever anticipated. As I introduced earlier, I think there's going to be a substantial battle about those and their age and the methods in which we're going to determine the actual age of those coming in. Now, at present, there isn't, if you're all aware, a single assessment method that's agreed between the parties which can determine an individual's age with precision. So that's very much up for grabs. Now, the Refugee Council, in their report of October of last year, in their own statistics, by highlighting the Home Office's own statistics, found that 3 in every 4 people across the channel would be recognised if we'd process their claims. They're of the view that it's simply unfounded to say that these people are economic migrants. 54% came from just 5 countries, including Afghanistan and Eritrea. Even if the Rwanda agreement were to be operationalised, even over 25,000 people would be left in limbo, as they would not be able to be returned to their home country or Rwanda. Now, the main provisions of the Act, and this is what becomes slightly more interesting, is this. People can be removed if it's considered safe to either the country of their nationality or where they hold an ID card or passport. I mentioned the 57 countries earlier. But what's really troubling is that the Act provides for the detention of people who meet the conditions for removal. So if you come in by boat now, you can be detained for 28 days and you're not going to be entitled to make an immigration bail application or even JR it. You're left with only a writ for habeas corpus, and that will mean that the High Court will be inundated with these applications. And that could lead to the release of detainees, but the whole idea is to restrict access to justice, as I mentioned. What's also troubling, and I'll go back to my friend who's an immigration judge who will remain unnamed, and I spoke to him about what he thought were the main concerns about the bill. One of them that he shared was this: that let's say for a moment you've met the requirements for removal, that you've met what the Illegal Migration Act catch-all was supposed to be about, and you later get leave to remain. No matter how much you try, that will not give you a route to British citizenship. And this rule will apply to anyone who arrived after the 7th of March 2023. The Act contains a duty to completely disregard refugee or human rights applications, a JR application. But going back to the example that I used of my Albanian client, who I acted for on a pro bono basis, it would exclude her claim on being a victim of modern slavery or trafficking, unless there are compelling circumstances for needing the individual to assist in an investigation or prosecution. Well, you know for a fact, we all know, if we deal with modern slavery and trafficking claims, that victims find it very difficult to assist in such prosecutions. It's just the nature of the coercive manner in which they've been brought in and the fear that they have. So that isn't a particularly impressive mechanism that overcomes an exclusion of a claim of modern slavery or human trafficking. Now, what's also further troubling is when a person is given a notice of removal to a third country, they've only got 8 days to make a claim that their removal would result in the following test: a real, imminent, and foreseeable risk of serious and irreversible harm, or that a factual mistake has been made in determining that they were an illegal entrant. So the two issues that I can see if we were sitting at sunny Hatton Cross today, where the ground floor has been converted into quasi-cells and further security doors have been put in, is that those who come in illegally are going to find themselves within that very short 8-day window of coming to court to establish, first of all, the date that they arrived, and also possibly to explore whether a factual mistake has been made or whether they could demonstrate a real, imminent, and foreseeable risk of serious and irreversible harm. It's going to be quite tough, in my respectful submission. Late claims will only be accepted where there are compelling reasons all other legal challenges to removal, whether on human rights grounds or other grounds, will never prevent a delay. It also means that ministers are going to be given the discretion to disregard interim measures granted by the European Court of Human Rights. You might have heard Rishi Sunak talking about the fact that he feels that they should not, the ECTHR shouldn't get involved or even have the ability to make those interim measures. I think that's what thwarted the first embryonic challenge to Rwanda. Following an interim measure, a minister may decide against removing a person, but is not required to do so legally. He can continue with removal. He can go against the UK courts, and immigration officers must disregard the interim measure if he or she so wishes. Now, talking about to what extent the Act is coming to force. The Home Office held off on saying that they will not implement it until the decision from the Supreme Court in respect of Rwanda had come in. But we know that we've got that now. There appears to be a bit of a delay because I think the Home Office are half expecting a challenge in respect of the assurances that the government will get from Rwanda before they pursue this with some vigour. But looking at the way in which the immigration courts are being adapted at Taylor House and Hatton Cross, I half expect there to be implementation in a very short space of time. If we look at what provisions of the Act really have not come into force, most of the provisions have yet physically come into force, and that's including the duty of the Home Secretary to remove people to Rwanda just yet. Furthermore, this all came about originally as a result of the Conservative government's intention to overhaul the immigration system, something that Suella Braverman, in her short tenure, decided that was going to be her, if you like, winning ticket. Now, we know that from December 2020, the UK ceased to be part of the Dublin regulations, and no agreement was reached on asylum policy in respect of trade and cooperation. Now, the UK government expressed an intention, actually, to agree bilateral agreements with EU member states, but that intention was never fulfilled and no agreements have been reached. Furthermore, the purpose of the Act, again, is to go further than our 2002 Nationality and Borders Act, and basically gives substantial far-reaching powers to the Home Secretary to disregard the rule of law, in my view. And when we look at the statistics, the phenomenon of people arriving by small boats across the Channel began really in 2018, some vigor, increased in 2021. I'm going to have to read this out to you because I don't know these statistics off the top of my head. In 2021, 28,500 people were detected arriving by small boats. 8,266 were detected at ports, in lorries or shipping containers, airports or elsewhere. And by comparison, in 2022, the figure admittedly had substantially increased for small boat arrivals to 45,755, while the figure for people being detected in other locations hovered around the 8,000 mark at 8,808. Data issued by the Home Office shows that 15,826 people crossed the Channel in small boats from the 1st of Jan to the 10th of August 2023, bringing the cumulative total of arrivals since 2018 to more than 100,000. The government's latest projection for 2023 was that 56,000 people had come in, and in simple terms, the statistics suggest that 90% of those who arrived in the UK on small boats claimed asylum. However, small boat arrivals accounted for less than half, 44% to be exact, the total number of asylum applications in the year ending March 2023. Now, apparently, the government considered that there are safe and legal humanitarian routes to obtain refugee or other legal status. And in the 7 years from 2015 to 2023, 250,000 visas were issued under schemes for Ukrainians, 166,000 visas under the Hong Kong scheme. In the same period, 50,000 people were resettled or relocated, of whom 21,000 were through 2 schemes for Afghan nationals, and 46,000 family reunion visas were granted to members of refugees in the UK. But what troubles me is that when a minister was questioned on Question Time, and this was a good few months ago, to say, if we have a refugee, a young refugee, leaving the Yemen, for example, and his only way of coming into the UK is effectively to fall into the clutches of an illegal persons trafficker, because he has no other means of escaping the human rights atrocities there. Are we supposed to say, because he doesn't fit within a scheme, his claim is inadmissible? First rhetorical question. The second rhetorical question that was put to the minister by a member of the crowd is that, tell us how you enter the UK legally in order to claim asylum. And couldn't answer. I mean, the panelists at the time simply couldn't answer the question, and it was put at least 3 times. So I don't quite understand the mechanics of how the Conservative government thought that this could actually conceivably work. My cynical thought is this is nothing other than a political hot potato designed to garner votes from the far right, perhaps, because the Conservative Party are looking at a substantial loss. And the only way to get those votes is basically to stick to their guns as long as they can, even if it means that it flies in the face of every conceivable commitment to the Refugee Convention. Going back to statistics, around 90% of people who arrive in the UK on small boats claim asylum. And as I said, that the nationalities of people arriving by small boats mirrors the nationalities who are applying for asylum overall. And they're not all Albanians, as they said in the press. They're from Afghanistan, still has substantial problems, Iran, Iraq, and of course, Syria. Now, what concerns me is the Home Office at the moment have a policy for Syria in which, and Yemen in particular, in which if you're a national, you're given a form of discretionary leave to remain. But a lot of Syrian nationals enter illegally. They have to travel through other countries to come to the UK. Many of them don't speak English. Many of them don't speak any of the other languages other than their own natural home languages, as it were. What are we saying to them? That their claims are merely inadmissible? What if they have mental health issues? How do you get that before an immigration judge within that 8-day period? How do you meaningfully put forward your best case in that very short period of time? If we look at the practical challenges, the government says that the Act will operate by detaining people and promptly removing them. But the practical questions are, what capacity do we have to process the number of asylum seekers? Most, according to McKee, who have a contract with the Home Office, most of the detention centres are substantially full. It is for that singular reason why those facing criminal deportation are kept in mainstream prisons. So do we have the ability to house, first of all? Secondly, at the moment, we know that the Immigration Tribunal has a substantial backlog. We have hearings being converted to CVP at short notice. We have adjournments taking place quite regularly. There is a dearth of interpreters at the moment. And we're told that the Ministry of Justice can't afford to put as many feed-paid judges as they can. So how on earth are they going to manage the consequences and the practical consequences of this act? Now, if the trend of increasing irregular migration continues, the number of people subject to the duty to remove and the power to detain is, and when the act's fully in force, It's likely to be in the tens of thousands. And we need to put this contextually against the backlog of asylum claims. Now, as of July last year, it was 136,000. I've noticed recently that the quality of the decisions that we're getting, fortunately for us, from the Home Office in respect to protection-based claims seem to be substantially generic, seem to be particularly short. And I'll give you a flavour of what I've often seen recently is that you, the appellant, have failed to provide a clear and consistent and sufficiently detailed account. It's almost like reading a Stephen King novel. You're then waiting for this amazing punchline to pop out, but there's a failure to particularize why. And that's because the Home Office are under so much pressure to clear this backlog. Now, the second problem is the flow backlog of almost 75,000 newer applications made since June of 2022. And what's hilarious is Rishi Sunak pledged to clear the legacy backlog by the end of 2023. And in fact, when we do pre-action letters, we get that commitment in writing. But the Home Office is still not making enough decisions on historic legacy cases in order to clear that backlog. And also, what's also strange is that I'm seeing more so than ever a number of protection-based claims that are being treated as withdrawn on non-compliance grounds. And that has drastically increased the backlog. So quite how we can inherit the obligations that this Migration Act has is questionable. Now, the government's abandoned its ambition to make decisions on newer flow claims within 6 months, which means now it's growing even more. The Home Office estimates that the number of newer claims awaiting a decision will increase from 61,000 and has increased to 84,000 by the end of 2023. Now, I've attached a copy of the illegal migration bill, and it stated that the high number of people arriving in small boats has contributed to an unsustainable backlog of asylum applications. It should be noted that the rise in backlog predates the increase in small arrivals. So this is before the Illegal Migration Act was even born. Even before it was in its fetal stage, we had problems with the assessments of claims from those who came in illegally. And many were kept in temporary housing on the coast, were not screened in time, or kept for substantial spaces of time. NRM claims were not being done in time. Those problems still exist. Do we have, and I touched on this, do we have adequate detention and accommodation capacity to implement the Act? Well, let me just give you a flavour on the statistics. In December 2022, the capacity of the UK's immigration detention facilities were 2,192. But if 54,563 people entered the UK by irregular means in 2022, more than 80% by small boats across the Channel, where are they going to be kept? Sola Brahman had to throw the towel in when she was asked by the Select Committee in June of last year as to how that was going to be done. And then they decided to talk about floating barges. But as we know, the floating barges didn't get very far because people on the barges started to contract Legionnaire's disease. And that practice was stopped. Then we had Manston. That didn't work either. But the plan is that the Home Office want to open 2 further removal centres in Oxfordshire and Hampshire with a capacity of 1,000. But if you've got 54,000 people coming in who all potentially fall under the Illegal Migration Act net, we're still short of a substantial amount. Now, as of March 2023, 108,000 people were in forms of asylum accommodation. 45,000 were in hotels. I've already spoke about the Bibi Stockholm nonsense, and that contract was apparently worth 1.6 billion. That didn't work well. And in their infinite wisdom, the Conservative Party are talking about identifying for land-based sites. But then if we look at the maths, if after those 8 days we're unable the applicant has been unable to succeed in challenging his removal, what's the cost of removing an individual from the UK? It's circa £169,000. And the Home Office simply haven't thought through the costs involved in the same way that they hadn't thought through Rwanda and the commitment that they had made to the Rwandan authorities. But let's look at one of the final questions I want us to look at. Now, have these policies and laws, which maybe perhaps tactically were just introduced but never meant to be implemented, deterred irregular migration? In simple terms, the Act is a novel and untested scheme. There has been virtually no proper academic commitment or assessment. Many asylum seekers don't have an understanding of the procedures in claiming asylum, the frameworks involved, the length of time. And many asylum seekers do not choose their point of destination. The most senior civil servant in the Home Office stated that evidence of a deterrent effect is highly uncertain and cannot be quantified with sufficient certainty to the necessary level of assurance over the policy's value for money. So, I mean, if a Mandarin can't agree with the fact that the whole purpose was to also deter further costs, to mitigate further cost in respect of housing people, I'm not quite sure how far this is ever going to go. Looking at when the Act was first introduced, Suella Braverman said that the Act would always be compatible with the European Convention of Human Rights, and said that she would maintain that commitment. But instead, she took the unusual step of declaring that she was unable to make a statement of compatibility in relation to 3 provisions, but that the government nevertheless wanted to proceed with the bill. Now, the memorandum attached to the bill on its introduction identified one reason why the Home Secretary couldn't make such a statement: the fact that the duty to remove, the power to detain, and the permanent ban on being granted citizenship status apply to victims of modern slavery. The memorandum justified this approach by saying that radical, unpopular solutions were required to put a stop to the small boats crossing the channel. 2 further provisions were later identified as potentially incompatible with the ECHR, and it's something I touched on earlier, and that the first makes it harder to challenge a child assessment or age assessment. The other gives immigration officers new powers to search, seize, retain electronic devices, and in effect to scrutinize them. And with regards to the suspension of modern slavery protection, the Parliamentary Joint Committee on Human Rights says it's overwhelmingly clear that this would breach Article 4 of the ECHR, which prohibits slavery, as well as several of the UK's obligations under the Council of the Europe Convention Against Trafficking. The JCHR also raised concern about giving ministers the power to decide whether they should adhere to interim measures. The JCHR said this power, which had not come into effect, is something I touched on earlier, permits deliberate breaches of the UK's obligations. So what's the point of us, if you like, having any link with the European Convention on Human Rights? Rishi Sunak said that the UK will remain a member of the ECHR, but then the Immigration Minister, Robert Jenrick, in August of last year said the government will do whatever it takes to defend borders, or in brackets, get votes. Some Conservative MPs have said that the UK should withdraw. Suella Braverman's view, who no one really listens to anymore because she has paled into some weird insignificance wherever she is, said that her view was that we should leave the ECHR. But she was also in the same interview saying how proud she was of the British Empire. To leave the ECHR, a state must give 6 months' notice to the Council of Europe. Council of Europe, as you know, is a 46-member international organisation. At a domestic level, this would require substantial changes, such as repealing the Human Rights Act 98 through an Act of Parliament. That would have a knock-on effect in respect of all devolution legislation that we've got with Scotland, Northern Ireland and Wales. Now, the EU overall has said that it would terminate cooperation on criminal matters if we were to leave the ECHR. Members of the House of Lords have expressed their concern that it could breach it. And in simple terms, there are overwhelming views that this entire piece of legislation is so dangerous, is so toxic, is so incompatible with every conceivable concept that we understand for protecting those who are vulnerable. Now, the UNHCR Commission, the UN High Commissioner, rather, for refugees issued a joint statement saying that the Act is at variance with the UK's obligations under international human rights and refugee law and will have profound consequences for people in need of international protection. They say that the bill extinguishes access to asylum in the UK from anyone who arrives irregularly, barring them from presenting claims for protection, no matter how compelling their circumstances are. And I'm going to end and read out the final part of my chat today. And this statement from the UN High Commissioner for Refugees is damning. The Act sets a worrying precedent for dismantling asylum-related obligations that other countries, including Europe, may be tempted to follow, with a potentially adverse effect on the international refugee and human rights protection system as a whole. So in short, I think whoever's listening in today knows what my overall view is. I personally don't think that it's going to get off the ground. And I think that the Labour government that are coming in are unlikely to follow it. But who knows, quite frankly. Thank you very much. I think that's me done. Always earlier than usual, sorry.
Well, that's not a bad thing at all, Nishan. We're going to be on time for our lunch break. Now, thank you very much for that eloquent and impassioned dissection of the Illegal Migration Act. And I think we've all come away with a very vivid impression of what it's about and what it's intended to achieve. And you may well be right that it won't ever get off the ground, but at least we know what may be coming. Would you be able to come to the panel session this afternoon?
Yes. Now, it's circa 3 o'clock. Is that right?
That's right, just after 3.
I'm going to do my best to be there.
Oh, that's great. So hopefully we'll see you there. And everybody else, I'm sure you'll be looking forward to a break. And we do have a break from, in fact, well, starting from now, we're about 5 minutes early, until 2 o'clock. So we'll see you back here at 2 o'clock.
Will do.
Bye-bye
Thanks
for
again.
now.
Thanks.
Bye. Well, hello, everybody, and hope you've enjoyed your lunch break. We're back now for the afternoon session. And before we start, I should just make a couple of announcements, which I made at the beginning of the morning session, but some of you may have arrived since then. Really, it's just to say that on Tuesday, the 16th of April, we're having another webinar. This time, it's an update on family law. So if any of you have also got an interest in family law or have colleagues who do, you'll be very welcome to sign up for that session webinar on Tuesday, the 16th of April. Now, the other thing was just to remind people, if any queries arise that you'd like some discussion about in the course of the afternoon's talk, well, it's just one talk, well, before the panel session. We'll be discussing questions that have been put in the Q&A box this morning. And for those of you who have just joined us, if you have any questions arising from the next talk, please put them in the Q&A box. But here to give us the early afternoon talk is Julian Norman, and she's very welcome from Goldsmith Chambers. We will be having a panel session after our afternoon tea break when any questions which have been put in the Q&A box will be discussed. And then finally, I'll be bringing up the rear with the final talk of the day. So without any further ado, Julian has joined us in more recent times than some of her colleagues, but she's very welcome, and she's going to be talking about the future of the asylum process, and the dreaded word Rwanda crops up as well. So over to you, Julian.
Hi, thank you very much for the introduction, Richard, and it's a pleasure to be here again. I am going to be talking about the future of asylum. I feel as though really I should have a crystal ball here to use, but I don't have that, so I'm going to have to attempt to share my screen and some slides instead. So bear with me whilst I see if I can make the tech work. There we go. Now, if I make that play, is that working effectively? Can everybody see my slides? If somebody wouldn't mind just unmuting and telling me that the slide.
Well, I can certainly see it.
Excellent.
This is the first of your slides, isn't it?
This is just the intro, so brilliant. Thank you. Okay, so this is what the title of this talk is, What Next for the Future of Asylum? And as I said, this feels rather as though we need a crystal ball going on here, because of course the future is very uncertain at the moment. We have had a raft of legislation in recent years, and in some ways that's nothing particularly new. I've been working in immigration and asylum since 2002. So I arrived at the same time as the Nationality, Immigration and Asylum Act 2002, which was a huge landscape shift really back then. Since then, we have had pretty much one statute a year, with a few years omitted, and of course hundreds of changes to the immigration rules. So the chances are that if you work in immigration and asylum law, you are already very familiar with the idea that every year or so we tumble down a procedurally brand new rabbit hole from which we then have to extricate ourselves with some measure of compliance with international obligations. So we have had the recent decision in the Supreme Court, and that of course follows hot on the heels of NABA, which was 2022's contribution to statute, and the Illegal Migration Act, which of course you have just heard about in detail. Now, the progress of the plans for the IMA were stalled by the Rwanda case. That was the recent decision in the Supreme Court, and many of you will be familiar with that, but for those who aren't, a quick recap. When the IMA came in, a number of people were detained and told that they were going to be placed onto flights to Rwanda. That was challenged. Initially the High Court, of course, then the Court of Appeal, and ultimately into the Supreme Court. And the Supreme Court said, well, when we look at the situation in Rwanda overall, there is a real risk of refoulement. And that means the removal of asylum seekers to their original countries without substantive examination of their claims. So on that basis, the removals had to fail. So what happens next? Does the government quietly put Rwanda on the back burner? No. What's happened next is the Rwanda bill, which is still a work in progress. So let's rewind slightly. Let's go back many years to the Refugee Convention as we know it. Refugee Convention of 1951, and everybody listening, I think, will be very familiar with this. To qualify for refugee protection, you must show a real risk of persecution due to race, religion, nationality, political opinion, or membership of a social group. You've also then got European Convention on Human Rights, particularly Article 2, right to life, and Article 3, freedom from torture or inhuman and degrading treatment. And a successful claimant may get refugee protection, or alternatively humanitarian protection or discretionary leave. These are concepts that we're all familiar with. These have, up until recently, remained fairly unchanged since they were introduced in 1951. The difficulty that the government has, and this, of course, we are lawyers, we are not politicians, so this is not for us to grapple with. But as global travel has become easier, we now have to contend with a landscape in which many people in the world, sadly, are refugees. And the number who are able to reach Europe obviously increases. This is something that the authors of the Refugee Convention probably couldn't have envisaged. And of course, in the wake of the Second World War, their priority was protection rather than political analysis of the nature that we're looking at it now, going through the Commons and the Lords. So these are weighty questions, not just of law, but of politics. Fortunately for me, all I have to deal with in today's talk is the law. But there is some contribution in terms of when we look at what the future might look like. There is an element of second guessing how that might look and what different approaches might be. So let's have a look at the post-IMA landscape. This is what is intended by the Illegal Migration Act. You have already heard quite a bit about this, so forgive me if I'm repeating what has already been said, and no doubt better than I will. But the intention of the Illegal Migration Act is that there should be different treatment for different
I'm sorry to interrupt, Julian. We seem to be having some interference.
It's anticipated. Oh dear. Is that any better?
Actually, yes. You're sounding okay now.
Sorry about that. There was a brief flicker where it said my internet connection was unstable. So hopefully that won't happen again.
That's done the trick, I think. Thank you.
Do just pop up. The intention is that those who arrive via a safe and legal route will be able to get protection, as will sur place refugees and other capacity. And then, for example, when the situation in Ukraine began, the people who were living here, perhaps on work permits, perhaps on other sense to mean any type of if somebody is here and then the situation in their home country means it's untenable for them to return, they become a refugee where they are, and the French term is used sur place, on the place. Then there is going to be a further category. These are those who meet what are called the 4 conditions of the Illegal Migration Act. So these are people who enter unlawfully. So, for example, entry without entry clearance, those who enter in breach of a deportation order, entry via deception. That will be a very interesting one to analyse, because if somebody comes on a visit with the intention of going back, was their intention genuine or not? Those who come on small boats, lorries, so on and so forth, after the commencement date of the Act, and who did not come directly to the UK. And inevitably, there is going to be much discussion and no doubt litigation about what directly really means. So those who meet those 4 conditions of the IMA, the Secretary of State has a duty to remove them with some limited exceptions. Any asylum claim will be inadmissible. They may be detained whilst there is consideration and pending any removal. And because the asylum or human rights claim is inadmissible, what they can make instead is known as a serious harm suspensive claim or a removals conditions suspensive claim. It'll be appealable to the upper tribunal, but essentially only on a review basis. So very much akin to judicial review, where the tribunal will have to reconsider the decision of the Secretary of State, and then an onward appeal potentially to the Court of Appeal. And just a footnote on the second appeals test there, because the appellant must satisfy the second appeals test. I will be very interested to see what the Court of Appeal make of that, bearing in mind that it's not really the second appeals test if there hasn't been a first-tier tribunal decision. Will that be rigorously enforced or not? That remains to be seen. So the Rwanda bill, and what is it? How does it change things? How does it get in the way? And essentially what the Rwanda bill is intended to do is to allow Parliament to declare that Rwanda is safe. Despite the Supreme Court's decision that there is a real risk of refoulement from Rwanda, and that therefore arguably it isn't. Now, to those who are not immigration practitioners, that might sound absolutely absurd. What next? Can we declare that by operation of statute, all homeless people have houses, and that all those with no GCSEs can exchange that reality for a new reality in which they have a first-class degree? Can we end up with the best educated, best housed, most prosperous country in the world with no crime rate simply by operation of a declaration of Parliament? And of course, we can see the inherent absurdity there. But of course, immigration practitioners will know that this is not quite the first time that Parliament has declared something to be so simply by maintaining that it is. We've seen that before, for example, with the introduction of Section 117B, and immigration control is in the public interest, because when we look at Article 8.2, immigration control is not actually one of these Article 8.2 criteria. Immigration control was very often connected to the economic well-being of the country, which is, but not always. And there had been a couple of decisions where somebody who quite clearly was extremely wealthy, the court had stopped in the Razgar formulation at, well, what is the public interest that's being served here? It can't be the economic well-being of the country, because this person is in fact going to be very much a net contributor. And so the government declared that immigration control is always in the public interest, whether it is or not. And then, of course, prior to that, we had Section 8 of the Treatment of Claimants, etc. Act back in 2004. And that says that where somebody doesn't claim asylum on arrival, for example, it will damage their credibility. Now, in both of those cases, as you'll know, the tribunal and the appellate courts have softened the edges of that a bit. It's been a bit more of a sliding scale. So yes, it is in the public interest, but the extent to which it's in the public interest is up to the decision maker. It will damage credibility, but the extent to which credibility is damaged has to be assessed in the round. The Rwanda bill, I think, departs from that a little bit because it's very difficult to see where the edges of such a declaration could be softened. If Rwanda is safe or not safe, there is no sliding scale really of safety. So it's an interesting progression in terms of where we go there. So when we look at the bill as it exists at the moment, of course, this is not the final version. We don't know what will be the final version. It starts, as does the IMA, with a declaration from the Secretary of State that he is unable to make a statement that the bill is compatible with the Convention rights. So there we go. And we move on to what it actually says. The purpose is to prevent and deter unlawful migration. So exactly on all fours with the Illegal Migration Act. And it sets out that the Rwanda Treaty has been laid before Parliament. The Act gives effect to the judgment of Parliament that the Republic of Rwanda is a safe country. And it sets out a series of things that the Rwanda government is expected to do under the treaty. And that includes that any person removed to the Republic of Rwanda under the provisions of the treaty, which are to be called relocated individuals, will not be removed from Rwanda except to the United Kingdom. So obviously that deals with the issue of refoulement. If somebody comes from Iraq to the UK, from UK, they are relocated to Rwanda. From there, they cannot be refueled if this bill goes through and if Rwanda respects the agrees with these provisions of the treaty. They can only be sent back to the UK. What happens next? Are they then entitled to make an application for asylum in the UK, having been returned? That again remains to be seen. But I think in order to comply with our own obligations, that would have to happen. Any relocated individual is to be made available to return to the UK if the government of the UK requests them. The system for the processing of protection claims is to be improved. You might think that that is in the bill as it stands, slightly woolly wording. It doesn't say exactly how much by or what the metric will be of measuring that improvement. Relocated individuals are to be treated equally. Relocated individuals are to be provided with legal assistance for protection claims and any onward appeals. And it goes on to say, for the purposes of this Act, so this is the Rwanda Bill, a safe country means a country to which persons may be removed from the UK in compliance with all of the UK's obligations under international law, and where they will not be treated otherwise than in accordance with international law once there. Section 2 of the proposed bill says that every decision maker must conclusively treat the Republic of Rwanda as a safe country. That includes both the Secretary of State, any immigration officer, and any court or tribunal. And that means that any court or tribunal must not consider a review of or appeal against a decision of the Secretary of State relating to the removal of someone to Rwanda, to the extent that that review or appeal is brought on the grounds that Rwanda is not a safe country. In particular, a court or tribunal mustn't consider any claim that Rwanda would refool somebody, that they wouldn't receive fair and proper consideration, or any claim that Rwanda will not act in accordance with the Rwanda Treaty. But that is softened a little bit by Section 4, which says that Section 2 doesn't prevent a Secretary of State or the Secretary of State or an immigration officer from deciding whether or not Rwanda is a safe country for the person in question, based on compelling evidence relating specifically to that person's particular individual circumstances, rather than on the grounds that the Republic of Rwanda is not a safe country in general. And that allows both a court or tribunal and the Secretary of State to consider that. It's expressly said that that doesn't include whether or not someone would leave Rwanda in contravention of their international obligations. And it doesn't prevent an interim remedy if there's a real imminent and foreseeable risk of serious or irreversible harm. So there is some leeway within the proposed act itself. It's said in the treaty that those who are not granted refugee status or humanitarian protection could be granted permanent residence in Rwanda. And it's also proposed that there would be a new appellate system with one Rwandan and one Commonwealth co-presidents, and a judiciary with what's described as a mix of nationalities. Now, if that is correct, that those who are not granted any form of protection status nevertheless will be granted permanent residence, we will need to look at whether or not that is an adequate fallback position for those who are proposed to be sent out there. So can any claim still be brought? Yes, it can. It can be brought on the basis that the person's individual circumstances would leave them at risk. So I think we can all come up, everybody's first thought there is going to be people who have mental health difficulties, post-traumatic stress disorder, and my experience, I don't know about yours, but certainly mine is that those who have arrived on small boats very often have some form of trauma-related mental health difficulty. But it means that we will not be able to argue that Rwanda itself is unsafe. Between those two positions, can we argue that somebody's particular circumstances means that they would be unable to take advantage of the protection or residence granted in Rwanda? And that would need to be considered based on their personal circumstances. We would need to be looking, for example, not just at mental health, but also at physical health, literacy rates. Do they speak any other language? Are they somebody who would deeply struggle with acquiring an additional language? What type of provision would they be entitled to in Rwanda if, for example, they have a learning disability that would prevent them from learning in an adequate period of time a language with which they could get by in Rwanda? Are they gay, LGBT, or otherwise members of a social group where they would struggle to integrate into Rwanda? All of these things, I think, remain up in the air, but it will need to be very much focused on the individual rather than on generic country evidence, and certainly not generic country evidence about Rwanda. So with that in mind, I have promised a set of top 10 tips for our future practitioners. And of course, this is very much predicated on there continuing to be an asylum system here, but one where in this hypothetical future, the Rwanda bill has gone through, people are being removed to Rwanda, and there is ongoing litigation surrounding who may have their claim considered here and who is going to be sent off to Rwanda. I don't think, absent my crystal ball, that I can say anything more specific in terms of where we are going than that. So the first one is check your dates. And by check your dates, I'm talking there about the dates of clients' arrivals, dates of detention, all of those sorts of dates. And the reason for that is that within the Illegal Migration Act itself, there are different dates coming in. So, for example, the 4 conditions are not yet in force, except for the purposes of those who are already here, who might leave the UK and then make a future application. For them, that is already in, and that is from the 7th of March. These are the types of dates you're going to need at your fingertips. So when advising somebody who is here already, for example, you might have somebody who arrived post 7th of March. They've made an asylum claim, they've been refused, but they now have a fiance. Their fiance is expecting. This has been obviously a whirlwind romance, and they want to return to the UK. They're saying, you know, I don't want to go through the appeal process. I just want to go home, apply for entry clearance and come back in. If it is post 7th of March, you need to advise them that they might not be able to. So it's that type of thing that you need to look out for. You need to be absolutely on top of those dates. Dates of detention, because there are going to be quite strict deadlines, timelines in terms of how long people can be held for and in what circumstances. Do keep an eye out for those, because it seems that you will need to be able to put in your application on the day that expires and so on. The next one is check your dates again. Dates are going to be really important as we move forward. And this is the one, the dates that the different provisions of the Illegal Migration Act enter into force, the date on which the Rwanda bill becomes law, if indeed it does. You will need to keep an eye out for new provisions coming in. The IMA contains a number of clauses which allow the Secretary of State to make regulations. That provision of the Act can come in, and then the regulations may not be made for some time after. These are going to be absolutely key. And where perhaps in the past it's been realistic to say, well, I know what the Refugee Convention says, and I know what the deadlines are to appeal. You are going to find yourselves, I think, with clients in very different situations, depending on what date they've entered, what date the provisions come into force, what date any regulations enacted by virtue of the IMA subsequently comes into force. So stick like glue to those provisions. The next one is familiarise yourself with judicial review, and I put that in because there is going to be more of a review style approach, I think. Whether or not Rwanda actually takes off, it does seem that there is going to be more of a review approach by the tribunals in place of what has been the familiar appellate system. Will that take? Because of course we have seen previous attempts to revise and reform the immigration appeal system. For example, you can now only appeal on Article 8 grounds. It took a little while, but we now know that if somebody meets the rules, that is positively dispositive of their Article 8 appeal. So that's still, we do sort of still have the ability to appeal under the rules. It's just that it's under the rules by operation of Article 8 now. So is this something that will actually take? We don't know. We don't know whether a more appellate system will actually end up being in place. But just in case, and bearing in mind that the provisions of the IMA do envisage a number of appeals going directly to the upper tribunal for a review of the decision, and that a number of different decisions could be susceptible to judicial review, with the exception, of course, of detention, for which there will be recourse to habeas corpus. So these are things that we do need, whether or not you intend to actually bring judicial review proceedings. It's a good idea, I think, to familiarise yourself with at least the basics of how a review rather than an appeal would work. For those who are sitting on smorg style mountains of gold coins. This book is absolutely invaluable. It is Fordham's Judicial Review Handbook, and it, I think, is absolutely superb. So if you are after an introduction that is, I won't call it accessible exactly, it's not bedtime reading, but it's certainly a very, very good introduction. Become a procedure diva. Procedure is something which I think is often overlooked a little bit. We take our witness statements, put in a bundle, and often that is as good as it gets procedurally. But procedure, I think, is going to become more and more and more important. We can see within the IMA, the intention is to really restrict, is perhaps not the right word, but really to sort of tighten up the procedure in terms of how long somebody can be detained for and so on, what the deadlines will be for your serious harm suspensive claims and your removal condition suspensive claims. And you cannot afford to lose on procedure. That would be so easy to do, and it is just such an open goal. So do browse through the procedure rules, the practice guidance, and the practice directions. They are so incredibly helpful. So for example, if you have a client who is a vulnerable adult or a sensitive witness, the practice direction says that there is no expectation that they will give evidence unless the judge is satisfied that it won't be harmful to them, or that otherwise that it's necessary for that evidence to be given. That is really useful, because if you ask the judge at the beginning of a case to go through that exercise of addressing whether or not this person's evidence is necessary when balanced against their mental health, it really does focus not just the tribunal's mind and approach, but also really does focus the presenting officer's mind as well, on the fact that this is not a statistic sitting in front of them. This is the person who has experienced some level of trauma. So that's just one example of where procedure can be used very valuably in your favour. The next is in the same vein, really. We have got to keep on top of deadlines. These again get tighter and tighter. If there is one prediction I can make for the future of asylum, it is that deadlines, and they're not optional at the moment, but I think that they are going to get even less optional as we move forward. We can see from how the IMA is drafted that the intention is going to be very much arrive detained for a set period of time, decision, serious harm suspensive claim if one goes in within X number of days, I think it's 7 days, decision after that within 4 days, off to Rwanda or wherever it may be. I think the other alternative is hoped to be France. And each of those will have a deadline. Now, my perhaps slightly more cynical prediction for those deadlines is that the Home Office, as it stands at the moment, is in absolutely no way prepared for this. And the chances of getting a decision in 4 days is deeply unlikely. But if it all goes to plan, and if that is something for which the recruitment is done, the training is provided, and it does all go the way that the government wants it to go, we are going to have to be so tight on deadlines because, of course, the risk of missing one of those is huge. The next part is loading them. This is almost exactly how we used to do it many, many years ago. Oh, I've just seen my connection is unstable again. There we go. That should be better. Where a person would be interviewed, would give a very, very, very brief witness statement. And then the interview process was where that story, that account would be gently brought out, examined, the credibility of it, of course, tested, then the refusal letter, and then if a more detailed statement was needed, that went in at the appeal process. That just can't be done anymore. The witness statement needs to be really detailed. It does need to include things like, has this person had any level of education? What do they know? If they don't know much about the political party they belong to, or the arrest warrant that came to their door, or whatever it might be, why not? Almost preempt the potential refusal points. And that is really important for these serious harm suspensive claims if we get to the position of making those, because they have to be supported on application with what is described as very compelling evidence. And if we don't have that, they will be refused and certified as clearly unfounded. And then it will be JR, if indeed a JR, sorry, it won't be a JR, it will be an appeal, but application for permission to the upper tribunal. So the benefit of having all of the material available for the decision maker as early as possible is enormous. On a similar note, if you've got 7 days to put in a serious harm suspensive claim, that's assuming that your client has got in touch with you the very moment that they get their decision, which they might not. You need the background material at your fingertips. So you need a bank, if you don't already have one, and I know a lot of solicitors do keep these, of up-to-date materials so that you can say, okay, this person is from this country, this is their account, this is their risk. In that case, I am going to need the amnesty report, the CPIN, the US State Department report on human rights practices for the last year, these segments of it. And you need to know where to find that, and you need to know how it relates to your particular client. Keeping these is really, really useful to be able to pull those out at short notice. But having said that, don't throw in generic applications. It's very tempting to say, okay, my client is a Kurd from Iraq, for example, therefore I'm going to put in every country guidance case on Iraq and every piece of background material I can find on Iraq. 95% of it relates to Baghdad. That's not helpful to anybody, least of all the decision maker. So just do be aware, bank of background material is valuable. Generic applications can actually obscure your better points. And make it personal. So this relates back to what I was saying earlier in terms of what types of claim will still be envisaged under the new Rwanda bill. They need to be personal to your client. Saying Rwanda isn't safe, even if it's Rwanda isn't safe for my client, isn't enough. A claim that Rwanda is not safe won't be allowed. But a claim that your client won't be safe in Rwanda will. It's perhaps a slightly nuanced distinction, but it is nevertheless a distinction that is there. And if it is there and it is something that can be used to keep your client where they are, then that's obviously in your client's interests. And ultimately that is our job, is to act in the best interests of our clients. So the personal information about your client isn't just there as background noise. It's not just there as a sort of cover sheet to the application. Within that personal material, you may well find information that goes to support a claim that your particular client isn't safe in Rwanda for specific reasons, notwithstanding that Rwanda is, as declared by Parliament, a safe country. So do keep that personal. And then finally, collaborate. This is a lot of law that we have had in the last couple of years. The combination of NABA, the IMA, the proposed Rwanda bill, the newer approaches to trafficking, and that's even without the so-called secret policy that was revealed in KTT. We do need collaboration with one another. We need to know what other people are arguing and what they're doing. And we need to be able to give one another a heads up when, for example, a new provision of the IMA has been enacted. I do think it will be genuinely difficult to keep abreast of it by ourselves. So I would say do seek advice from counsel early on. And of course, we are here for anybody who wants to run something past us or have a quick chat. Do keep up on social media, legal platforms, legal Twitter, whatever it is you use, free movement. All of these things are so valuable. And as we see everything settle into place and we get to grips with what the new legal landscape will look like, that level of support between ourselves and between solicitors and counsel at an early stage will be valuable. So we are there and do use us. And on that note, there's my details there for anybody who needs them. I finished 10 minutes early, so I've got 10 minutes for any questions or discussion. Or Richard, if you want to add that onto the general Q&A, we can do that too.
Well, thank you very much indeed, Julian. That was a very lucid and clear, except when there was a bit of interference, a very lucid and clear exposition of what is in store for us with the IMA and the Safety of Rwanda bill and so on. And gosh, you've got through it early, as you say. Well, it may be a good idea for everybody who's available. At the moment, I see, oh, Samina is there. I don't think Sarah has come in yet. But I think, well, maybe just check if there are any specific questions for you, Julian, on the Q&A. There may not have been much time yet. I don't think so. Can't spot any yet.
I can see one on general time frame. A case can be in the third country unit for investigation.
Yes.
It will be applied to those who came to the UK before 2023. Okay, so for those who came before 2023, they can be considered for a third country removal where that is still available. And of course, we've got the dip in whether or not that's available at all, bearing in mind the Brexit situation. But in terms of, I can see the question is specific to some of our clients have been under investigation for Rwanda removal for more than 8 to 10 months. I think they can remain in the third country unit, but they can't be considered for removal to Rwanda unless or until the Rwanda bill is passed. And even then, at the moment, the 4 conditions, section 2 of the IMA is not yet in force. So I don't think that they can be removed to Rwanda unless there is some further updated guidance or secondary legislation introduced. Unfortunately, under consideration, generally, other than to Rwanda for more than 8 to 10 months is not unusual at the moment. We're seeing people waiting for 2 years or so before they get a decision. So it's possible that that they're not actually being considered for Rwanda anymore, but they are just in a very long queue. Probably worth a subject access request or a further investigation as to exactly what the Secretary of State is doing with these applications. And it may be that you don't get an answer unless you threaten a pre-action protocol. So see where you go with that. It may take quite a lot of chipping away.
Well, I tell you what, why don't we have a longer tea break? And then we can start the panel as it's meant to start at 5 minutes past 3. And that'll give people time if they want to type in more questions into the Q&A box. And well, Julian, thank you very much indeed for that excellent talk. And look forward to seeing you in another 15 minutes or so at the panel. So I'll sign off myself now and see everybody back here at 5 minutes past 3 on the dot. Bye-bye.
Thank you, Richard. See you then.
Yes. Welcome back, everyone. Hope you had a good tea break. And we're now going to start our long-awaited panel discussion. And I see we've got Julian here, and Samina, and Sarah, and I think Nishan is on hand. He's just joining. Hello.
Hello.
Well, here we are. That's great. And we've got a number of questions that we can deal with. Who would like to kick off from what we've seen in the Q&A?
I was just going to say, in relation to one of the questions I was asked before, and I did answer, I just wanted to add, I think it was about the EUSS children born after someone had settled status. I just wanted to flag that they may well be entitled to British citizenship. That's right. So if one of the parents, I can't remember exactly the scenario, but one of the parents had settled status, one had pre-settled, then if they were born at the time one of the parents had settled, I think it's likely that they're entitled to British citizenship, so they can look into that kind of scenario as well. Look at that as an option.
Yes. One thing that struck me, Samina, when you were talking about the adult dependent relative route and breaking it down very logically into the various components that you have to go through, and ending up with Article 8 at ADR 0.7.1. In fact, I've seen 2 or 3 refusal letters in which they seem just to have skirted round or skimmed over the financial requirements without really looking into it at all. They just say that's accepted, and they focus very much on whether the applicant really does need long-term personal care and whether that's needed for everyday tasks. And then also, why can't you put her into a home, in your own country? Well, why does she need to come to the UK? And then they look very briefly at Article 8, and they say, you have not provided evidence of any exceptional circumstances in your case. And therefore, because there are no exceptional circumstances, I refuse on this ground. And in fact, if you look at ADR 0.7.1, there's no mention whatever of exceptional circumstances. Now, there used to be when the ADR route was in Appendix FM. It came under Gen. 3.2 and 3.3, and there had to be exceptional circumstances then before you moved on to whether a breach of Article 8 would occur because of the unjustifiably harsh consequences for the applicant and her family. But as I say, there's no mention of exceptional circumstances in the new ADR 0.7.1, and it must be a mistake of entry clearance officers to draw attention to the fact that there are no exceptional circumstances put forward by the applicant. Anyway, that was just something that struck me.
Yeah, it's interesting because they seem to be using all the words interchangeably, and I think that some of the case law provides that unjustifiably harsh may equate to exceptional, but I think it's right that they should use the right terminology depending on what they're refusing it under. So
yes. Ooh, no, is there anything else that we can spot in the questions and answers?
I've got one more about Rwanda in the Q&A. Can you please advise on how to challenge delays in the asylum claim caused by the notice of intent to send someone to Rwanda, which is up in the air at the moment? My client has been waiting for 1.5 years to be sent to Rwanda, which is absolutely horrible. And I mean, yes, that is awful. I think what you will probably need to do would be to threaten a judicial review with a pre-action protocol letter for the ongoing delay on the basis that proposed removal to Rwanda from 18 months ago must be unlawful in light of the Supreme Court's decision. And if they want to have another stab at it in the future, they need to wait for the Rwanda bill to pass into law. And they also need to wait for the 4 conditions to be met. I don't think they can just keep these applications on ice forever. And if you were minded to start digging around for disclosure, you may well find, I don't want to utter the word secret policy, but you may well find some form of policy that these are just not being considered for now, for policy reasons rather than anything else. So I think that would be my preferred route. But having said that, I'm a very big fan of judicial reviews. So I will threaten judicial review for anything. It can be quite an effective tool when used properly. So I think I would probably start with a PAP letter for delay and see where it got us. Because you may also find that after a pre-action letter, they come back and say, oh, we promise to consider it within 3 months, because that does happen sometimes.
Thank you.
Can I just add to that? I think what Julian said is right. We definitely PAP it. I've PAP'd one recently, and I do think there is a lot of credence to that secret sort of policy issue. They keep extending my PAP deadline, and they've done it 3 times now. And I've said, I'd like an explanation, please. And all that we get is that checks with the relevant department are ongoing. So that we can meaningfully go for it. But they're not going to get, I agree, it can't sit on ice. But also what you said, I think a subject access request. I did that after the 2nd extension for a PAP, and I'm waiting for that to come in. So yes, I think, but perfect advice, and definitely there's something going on. They're trying to buy time until those 4 teething issues are sorted out, so that they can try and start doing this again, and I think I think Rishi Sunak's got a 100 quid bet with Piers Morgan at the moment. So let's see what happens to that.
They seem to be delaying responses to other pre-action protocol letters as well. Nothing to do with asylum, but they say, "Oh, we can't give you a reply just yet." And I've even seen one where it says sort of every 14 days. In the past, we were meant to have replied, but we haven't been able to, and we still won't be able to for the next 14 days, without actually saying why they can't do it. So, I don't know, understaffed?
isn't that ground in itself?
Could be.
Yeah, understaffed, but we're still going to introduce a new act, and we're going to still manage all of the issues that go with that.
Yes, indeed. Well, let's have a look in the Q&A box, and here's one. Our client is on a skilled worker visa, being a new entrant, under 26 years old. His employer checked under the 26 and the new entrant columns in his costs. As we know, a new entrant's maximum time limit is 4 years. Oh, I didn't know that. Not 5. The client visa is valid for 5 years, from September 23 to September 28. Oh, so he's got leave to enter then for 5 years, but his certificate of sponsorship is only valid for 4 years. What does he or his employer need to do once his 4 years as a new entrant are completed? Well, issue another course, I suppose. Would you think that would be sufficient?
Yeah, I mean, I think it might really. I can't see for some reason the question on the Q&A. This is in the health and care visa context, right? Or
Oh,
more generally under skilled worker.
Oh, I think it's just ordinary skilled worker.
Okay, ordinary skilled worker.
Mm.
I mean, I don't have it on my fingertips, so I'll defer to others. If I might not be right, which I'm querying whether I am right or not, in saying that I think you need to look at the provisions in that if there's a max 4 stay just on being a new entrant. I don't know what the delta is in terms of the age. So obviously, if the person at the time of renewal will be over age, will be in a position where you'll need another cost and so on. So I think it needs to be looked at in a slightly more detail, because it may be that their extension application in any event it is obviously dependent on whether that condition that got them the visa in the first place still needs to continue, if that makes any sense.
Yeah, so if he's no
so I think it's tricky to advise specifically on a case like this without sort of knowing exactly where the person will be at job-wise, age-wise, etc.
Yeah, he may no longer be a new entrant, and there may have to be a higher salary that he needs to meet rather than the reduced one for a new entrant. Oh, I think you may have mentioned this already, but are the lower rates like 80% or 70% of the general salary threshold, are they continuing with the increase?
Yeah, so that's what I was going to check. So I didn't manage to put it in the chat box because the only reference that I had time to check in between it is in the announcement of the 30th of January. So the same link to the government's website in terms of that announcement that I put in my slides. And it does say, so I'll just read it out. So the changes will include, and then it's the second bullet point in that list there, the laying of the immigration rules, which would include the removal of the 20% going rate discount for occupations on the shortage occupation list on 14th of March. So the announcement did have a different start date than the 11th for that particular change. And then I started looking through the statement of changes itself, but I lost the will to live because I couldn't quite get to the answer using the search tool. So full disclosure on my side, I couldn't trawl through all of it in the time that I had.
It may be that it's only the shortage occupations that will no longer get the discount.
Yeah, so that's
get it for the new entrant or the PhD.
Yeah. So that seemed to indicate from the announcement, but obviously that announcement is a bit of a, it's a summary, isn't it? So always best to check.
Yes. Yeah, so if it's only going to be the shortage occupations that don't get the discount, I suppose that's compensated for by the fact that you wouldn't be a skilled worker at all unless you were in a shortage occupation. So that's though I think there will be fewer. I think just 21 occupations in the new what's it called? Oh dear, I forget what they've rebranded the shortage occupation list as. The general salary list, something like that. Yeah.
Going rate salaries.
Yeah, so there'll be fewer shortage occupations on the list. Yes. Well, now I'm looking at one from Koshi Blavo Barna, who says, somewhat angrily, despite concessions, my view on the increase in salary threshold on the family route is nothing more than discriminatory. There's nothing positive about any of the throw-in concessions. Does anyone think it is a possibility that this increase gets overturned? Well, I should think very unlikely. Oh, Samina, I think you muted?
I am.
Well.
I said, didn't we see the litigation with the 18,600 Lebanon?
Yep.
And they still found it to be lawful, the increase. So I think that we will see litigation in relation to it. But I think I highlighted in my talk that the justification appears to be that the thresholds are being raised to be on par with the general skilled worker. I think 39,800.
38,700.
Yeah, so the other way back. So that's the top end increase by 2025. And that's going to be consistent with the general skilled worker
Yes.
income.
Yes, indeed.
Yeah, and I think it depends on how they implement it as well, I think, because the litigation, forget the name now, is it Lebanon, wasn't it? Lebanon, yeah. You know, that was at a time, obviously it was preemptive, I think, and they hadn't, so there wasn't all the flexibility that there supposedly is with third-party financial and other specified evidence now that you can use and so on. So that's what, I mean, Lebanon was successful to the extent where there was some leeway, you know, there had to be some flexibility and there was detailed guidance and stuff.
Yes.
So if they continue to implement it with that in mind, of course, it's a higher, you know, it's a higher shortfall to meet now through other means, which might be impossible for many.
Yeah, so even with the possibility of third-party financial support and so on, but that could be discriminatory. What about the people who don't have third-party support? Now here's one about bookended overstaying, and the attendee says, as I understand it, it relates to previous periods of overstaying. Please clarify what is open-ended overstaying. Is the current period of overstaying, as referred to in Rule 276b(5), the date of the application for ILR? Yeah, I think that's right, isn't it? The bookended overstaying has to be in the past, so there are periods of leave on either side, and yeah, open-ended is when it's ongoing at the time of the application, isn't it?
Yeah.
Yes. So there we are. I think we've got an answer here from Roshana Mishra to what we were talking about previously. The cost needs renewal by the employer. That's for the new entrant. But as we were saying, there could be different requirements this time around for the costs. No, here's another new one. Where an applicant who is already in the UK on a graduate visa route applies for a healthcare visa after the 11th of March, does the new rule mean the dependent cannot join on the visa despite being resident in the UK before the 11th? Yes, I'm sure you have to be in the route already before the 11th of March as a health and care worker, not as some other category like graduate. So yeah, so if he only applies for a healthcare visa after the 11th of March, he won't be able to bring dependents. Yeah. Okay. Now, here's another one about a healthcare skilled worker. Can someone who entered the UK to work as a care worker but was never offered the employment he was sponsored on switch into another category within the UK if his leave has not yet been curtailed by the Home Office. Okay, so he got a visa as a care worker, but when he came, he wasn't able to take up the employment. So can he switch into another category while his leave is subsisting? It hasn't been curtailed yet.
Yeah. I mean, in theory, but I think, again, you've just got to tread very carefully and cautiously. It would depend, you know, factors that it would depend on why they weren't given the position. So it says never offered. I don't, you know, obviously there could be something untoward going on there in terms of on the employer side, but it could be on the applicant side that, you know, this changed their mind or whatever, because all of those factors may carry forward into an assessment in the next application by the Home Office as to whether the person applying is a genuine worker. In that sense, their intentions are genuine. So I don't think there's any, from memory, prohibition in terms of health and care worker visas switching into different categories, as we saw a lot of the categories can switch into this visa. So it tends to work both ways. But it would just, obviously, you'd need to delve into what happened and then put forward, you know, then obviously the person needs to be able to sponsor it if it's another sponsored work visa, get through that. And then obviously, you know, just be mindful of any general either suitability grounds or an assessment as to genuineness.
It's a not unusual experience for care workers to have already paid a lot of money to a middleman to get them an introduction to the employer or the agency who will be employing them in the UK. And then when they get here, they find that they aren't earning nearly as much as they expected, and they're having trouble paying for their own expenses as well as sending money home. And as in this case, they aren't able to take up the job at all.
Yeah. Yeah, and I think, you know, in those scenarios, I think, you know, although in theory it's very different sometimes what happens in practice, but in those sorts of scenarios, you know, we can only encourage the disclosure of that, and you know, for the applicant to inform the Home Office of any difficulties experienced and so on, so that that's not counted against them further down the line, that they can distance themselves from any wrongdoing, and then obviously for that to then stop happening. But obviously the will to do that sometimes is obviously, understandably, again, very hesitant.
Indeed. Oh, now here's another one to do with the skilled worker route. Can you please advise whether a British citizen running his own engineering business in the UK can employ his brother or sister-in-law from abroad as skilled workers? Well, I think nothing wrong with that in principle, but there might be a query as to whether there was a genuine vacancy for them.
Yeah, absolutely. That I would just add that there was a concern at some point with the sole representatives when there were family links, and that was then effectively shut down by the Home Office, but that hasn't carried forward in the skilled worker route. And as you say, it is really goes down to the genuineness of the vacancy and just being mindful of that to be able to counter any points taken by the Home Office.
Now, here's something completely different. A Hungarian national has had a deportation order issued against him. He arrived in the UK at age 8, schooled in the UK, and he was in the UK before the end of 2020. He had an in-time EUSS application pending at the time of the deportation notice. The tribunal has determined that the exception at section 33(6) of the 2008 Act, isn't it, did not apply to him because he did not have any leave to remain in the UK. The problem with this position is the preservation of existing rights. regulations for those with existing rights before exit day. What can we do? So he was in the UK before the deadline of the 31st of December 2020. He was Hungarian. Now, it doesn't say when the deportation order was issued against him.
I think also what's missing is the date of the offending behavior.
Offenders, yeah.
Yes.
So if it's pre the specified date, it would then it would fall to be considered under the EA regulations or the EUSS, but post it will be considered under domestic provisions. Can I just say, with deport cases, they're so complex. Each case, EU deport cases or with elements of EU, each case is just going to turn on its own facts. And this looks like a very specific question that would need like certain parts weeding out of it. And I think all of us on this panel have had experiences with those kind of EU complex deport cases that, you know, we're still scratching our heads about, and there's still no authorities on at the moment.
And also, just to add, the best thing to do when you find out the dates of those convictions, and if you find out that it's before the cutoff date, is to raise it by way of further reps, even at the stage 1 deportation stage. Don't wait to a stage 2. Most judges are quite live to it at the moment and are converting them to CMRs just to deal with this issue at the stage 1 stage, so that it doesn't mature to a stage 2. Because I think, unfortunately, although a lot of the non-deport cases are being managed well via HMCTS, these sort of deport cases, especially if someone's in prison, they're not getting CMR'd. So you're wasting a lot of time, and then decisions are being withdrawn and you're starting all over again. So it's the timeliness of it's really important, especially looking at the dates of convictions, as Sam said.
Thank you. Well, that's very helpful. Okay, let's see what's next. Yes, we've got quite a few. So here's one. An applicant who is progressing from Tier 4 student graduate leave, or an applicant under 26 qualifies for the lower new entrant salary. Oh, but they can only be a new entrance for 4 years. Then a new cost has to be issued for another year. Oh, I think this is actually the answer to the thing we were discussing earlier, that a new cost has to be issued, but maybe the amount of salary would be different. Okay. No, here's one about care workers again. Our client care worker visa was refused, and the wording on the refusal letter was, "You have paid the fee for health and care skilled worker visa rather than the fee for a skilled worker visa. Would you please address this?" Well, that's odd. If she'd applied for the health and care visa, that would be the fee that she was having to pay rather than the full skilled worker visa, surely.
Yeah, odd. I have to say I haven't had that query before. The only thing I can, just to flag, but I'm sure Wahid will be aware of this. I mean, the care workers only got added in 2022, I think. So if it was an old application, but I suspect it's not from the query arising today. I mean, I think go back to the team. They are quite, as you probably know, they are quite good in the in the skilled worker team at the Home Office. They are quite good at communicating, unlike other departments. And then there is this special helpline really dedicated for this visa and NHS work and so on. So it might be worth just trying to pester them about this and see if you can get clarification. But it seems odd. Yeah,
it looks like the caseworker didn't quite understand
I got a bit confused.
the difference between an ordinary skilled worker and one who's under the health and care.
Yeah.
That's rather, well,
But
much more
usually,
generous.
yeah, but usually also in terms of fees, they have got better about it. So if you have paid the wrong fee or you've got a balance to pay or whatever, they do contact you
Mhm.
mostly about this and say, can you pay the balance, and we'll then proceed to continue it under this, or it seems that this application is better suited, pay this fee, and so it is a bit odd. But I'd encourage you to engage, Wahid, with them and see how far you get, really.
Oh, yeah, that sounds very sensible. And here's one about a student. A student completed the master's degree, now on post-study working. Now there isn't any post-study work category anymore. There is the graduate route, but not post-study work. Currently doing odd jobs, because there are no jobs in the IT field. Will new rules be applicable to this student while applying for T2 visa? Oh dear, this is very odd. I mean, there isn't a tier 2 visa anymore either.
I think everyone keeps referring. I mean, I have clients who come in and keep talking to me about PSWs. I keep pointing out PSWs are long gone a while ago. And a lot of them come in with graduate visa questions, and many of them are on student visas and haven't, for example, finished their course yet, and they think they can switch across. But as we know, there was an amendment to the rules. With the greatest respect, I'm not sure how we approach this question.
Yes, well, he seems to be, he seems to have finished his studies, and but then, and he now wants to get into, well, what would be skilled work, I suppose. This is what he wants now. Will the new rules be applicable to this, well, ex-student, surely? It says this student while applying for the tier 2 visa. So he's currently doing odd jobs, and he was on post-study work, whatever that is. And if he wants to apply for a skilled work visa, the new rules, presumably that means the minimum salary. Well, once that comes into force, surely that would be the case. He would have to be offered a job with the minimum salary. Yeah. Okay. Well, now here's another one that they've been coming in thick and fast.
Richard, I'm going to have to seek your leave. I'm off to attend to daughter's pickups in 20 minutes.
It's
will you...
that time of day. Well, thank you
So will you
very
forgive
much
me?
for staying
And I'm
this
sorry
long.
to you all.
All the best, Nishan. Bye-bye
Thank you
now.
all. Thank you.
Bye.
Bye.
Okay. Now let me just go on to the next question. Now Sonal has a client who falls short of the £18,600 requirement. She falls short by £1,200 when taking into account her part-time income when she was a student and also her full-time income from November last year. Is there a way around this? So she needs to provide 6 months worth of payslips and bank statements, and those don't show that she's earned enough to fulfill the £18,600 requirement.
I mean, there's two things, isn't there? One is that she can be considered under EX.1, which is that she doesn't meet all the financial requirements. And then the second is it that she's made an application and her income from November 23 is now at the threshold. So she's got another, I think, two months maybe before it's 6 months, and then put in a Section 120 notice upgrade and say, now I've got the 6 months, can you consider my application? That is if the application hasn't been decided. And if it has been decided and it's pending an appeal, they do exactly the same, where you put in the evidence and say, I now satisfy it, can you reconsider my case? Or, you know, there's so many different options depending at which stage you're at. So I think that's the only way around it, really. You have to meet the threshold unless you're looking at EX.1.
Yeah. And
what happens if, when you apply at the date of application, you're not earning enough to meet the threshold, but by the date of decision or by the date of the appeal hearing, you are earning enough? Well, let's say it's an appeal. Can the appeal be allowed so that you get onto the 5-year route, or can it only be allowed under, well, Article 8, so that you're on a 10-year route? Because that makes a big difference, doesn't it?
Yeah, I think it would be allowed, but not with reference to the rules. So that's because it's at the date of application, they couldn't meet the requirements. And then it's a matter for the Secretary of State, depending on what they feel, that which route they put them under, because now they do satisfy it. And then if they want to switch into, once they're granted that leave and it's in the 10-year route, if they want to then convert it, upgrade it into a 5-year route visa, then they can do that by making another application, but that's another fee, isn't it, really? So unless they've made that, or they've recognized it themselves at that stage, then it's difficult. Does anyone recall the challenge to the leave granted policy? There's a policy, isn't there, where you can ask for reconsideration of the kind of leave that you've been granted. So you can.
There was a case which was before the previous president, and it was to do with whether whether you could complain about not being granted indefinite leave and you're only granted limited leave, and the answer was that a grant of limited leave is sufficient to avoid a breach of Article 8 because you're being allowed to stay in the UK. So you're not in danger of being removed. And the Secretary of State wasn't bound to grant you indefinite leave at that stage. So a further grant of limited leave was compatible with Article 8. I forget what the case was called.
Yeah, it's tricky. I think I think it, as Samina says, it would depend on, so I think there's stronger arguments to say it should be the 5-year route if the person meets the financial requirements by the time of the decision, but maybe not by the time of the application, even though the rules are termed against the application. But also for those clients now to really get speedy with their applications, because if there's trouble meeting, obviously, the lower income threshold, if they make the application before the rules change, they at least only have to battle to either meet EX1 against the 18.6 K minimum income compared to the higher one. And if you've got a shorter, it shouldn't matter, near miss cases don't succeed really, but still, in the mind of a judge or in the mind of the Home Office, if you've got a lower shortfall and you've got exceptional circumstances, you may find you're more successful in establishing EX1 than if you've got a 10K threshold, whatever, shortfall, whatever the case may be.
Yes, those rules where you have to satisfy a particular requirement as at the date of application are awkward, aren't they? Because with the passage of time, you may well satisfy the requirements of the rule.
Yeah.
But if one is sticking strictly to the wording of the rule, you can't be, your appeal can't be allowed under the rules, as it were.
Yeah.
So
And especially now when the appeal rights are different, you know, those sort of putting it in the PBS style against the application time was at a time when the appeal rights weren't necessarily limited to human rights. Human rights appeals, you're looking at the positions at the time of the hearing, so it doesn't sit, it doesn't sit very
well,
cleverly.
yes, that's right. The tribunal has to look at the situation at the date of the hearing because it is a human rights appeal by definition.
So it does cause quite a lot of, knots and
Yes, I think there's a lot of uncertainty among tribunal judges as well as to what to do in that situation. Oh, well, it makes work for lawyers, so mustn't grumble too much. Yes. No, here's one about, I think unmarried partners. In light of the Supreme Court decision in Chelik, is there any merit in appealing to the upper tribunal after a refusal at the first tier, or is it best to make an in-country partner application under Appendix FM, bearing in mind the applicant is facing allegations of a marriage of convenience, but he and his partner have not been interviewed? Okay, so they were, I think, hoping initially that they could be recognized as unmarried partners, but they've since got married. And after Chelik, is it worth appealing to the upper tribunal? So presumably based upon the senior court's decisions in Chelik, there's not much chance of success at the upper tribunal, is there?
I mean,
Though it's not very specific.
I think there's an attractive argument, isn't there, really, about wanting to clear the deck if there's a marriage of convenience allegation. And I know that I've certainly argued that before the tribunal before. But looking at strictly the legal issues, the courts are less inclined to kind of look at the wider issues if they can't pass the first hurdle, which is on the Chelik cases that they can't succeed for a very obvious reason, the relevant document. So it's a difficult one.
Yes. Well, I think we've got, we have run out of time, but maybe we can just squeeze in another couple of questions. I think the audience is very eager to hear more. So here's another one. In EU national deportation cases, usually the stage 1 notice carries a separate EUSS right of appeal. We have cases where we lodged in time EUSS appeal and then made Section 120 representations. Pending stage 2 decisions, sometimes the tribunal agrees to delay the EUSS appeal until a possible separate human rights appeal is lodged against the stage 2 decision, so that it could all be merged for one determination. However, in one of our recent appeals, the tribunal has refused to wait for a stage 2 decision and directed to proceed with the EUSS appeal, which could have costs implications for a client and also a partial consideration of his case. Could you advise anything in such scenarios? Well, I got halfway through reading that out and I regretted that I'd started because this is very complicated. And honestly, we've, already we're really out of time, so I think we'd best just leave this one. Okay, here's a short one. The Home Office responded to a care visa application, stating that the application is inconclusive because the certificate of sponsorship is invalid, without giving a further explanation. What could this mean? Well, inconclusive is a bit odd because if there isn't a valid certificate of sponsorship, then the application would have to be refused. So it's not as if it's pending. It's still pending, awaiting a decision. Surely it would be refused. But yes, so you would hope for an explanation of why the cost is invalid. But well, without seeing the refusal letter, there's nothing really that I can think of.
No, I think, I mean, again, see, you know, always worth contacting the team to see if you can get any further info, depending on who the person who's asked the question asks for, whether it's the applicant or the employer, you know, to do some digging of their own in terms of whether there's anything that they could think of that's led to that, and then that might inform the way they want to handle it. Worst case, it would be a PAP in terms of threatening, you know, JR in terms of not adequate reasons to understand the basis of the refusal. If it's a refusal, if it's not been refused and it's still pending, you know, again, you need to engage with the Home Office to try and figure this out. And if they don't engage in response to that, again, you could threaten, you know, taking action because they're just messing about. But yeah, a bit tricky without obviously the context.
Yes. Okay, well, definitely the last.
Just see what info you can glean really from any side.
Right, thank you. Well, definitely the last one. Will the spouse of a British citizen in the UK as a visitor face a citizenship ban if she makes an in-country partner application under Appendix FM? She also has 3 British children, all under the age of 5. So would a parent application be preferable?
That's interesting, isn't it? And the issue of the ban. Are you talking about character and an individual overstaying and having come on the visit visa?
I think that must be it. Would there be a problem with good character if and when she eventually applies for naturalization?
Can I just ask if that's a question about the 4 conditions being met, because she doesn't meet the 4 conditions of the IMA, 7th March 2023 or otherwise, unless she's made a protection claim, I think.
Ooh. Yes, well, she's not applying for protection.
She's not.
No, oh no,
And never
has. No, she wants to get leave as a spouse. But she came in as a visitor, and of course she can't switch under the rules to the spouse route. But she's worried that by doing this, by coming as a visitor and then applying for a different route, she could have problems later at some point when she applies for naturalization.
I can see that the question as well asks, would a parent application be preferable? But of course, you can't make a parent application under Appendix FM if the partner route is open to you.
Indeed.
So she's told to make the partner application, but should succeed on 117B6 on the basis that if the children can't reasonably be expected to leave and they're British, so probably they can't. But as to whether that would, it's not an automatic bar to citizenship under the IMA. But of course, we don't know what the rules will be like by the time she comes to make that citizenship application.
Yeah. Well, that's definitely right, Julian. The parent route wouldn't be open to her anyway, so she may as well make a spouse application. And with the 5 British children under the age of 5, well, that certainly strengthens her case. Oh, anyway, thank you all very much indeed for particularly staying on for such a long time. I think we could have gone on all afternoon and not have got to the end of it. But I think for my colleagues here, that is the end of your task for today. And I'll be bringing up the rear with a talk about the reform of the appeal structure in the last couple of years. So I hope that's not too boring and technical. We've already lost some of our participants. We were over 100 earlier on. We're down to 89, which still isn't bad. So anyway, with many thanks to Julian, Samina, and Sarah, and hope you'll all be willing to come again next time. I'll wish you cheerio, and I'll get on with my talk, for which I'd better share the screen.
Thank you, Richard.
Thank you.
Yes.
Bye-bye. Bye. Right, here I am. I think I just have to go up a bit now. Let me see. Ah. Here we are. We're getting to the top. Don't worry, it won't take too long now. Now, this talk is about what's called the reform procedures, which were brought in really with COVID, and the idea that you could have appeal hearings done online instead of face-to-face, and the various innovations that that accompanied this change of culture, really. So anyway, here we have my course notes on this reform program, and it involves quite a few changes to what we're used to. So, for example, tribunal caseworkers, now known as legal officers, with extended delegated powers to manage case progression and so on. And then something for managing the online system of appealing. Of course, it used to be all done on paper with notices of appeal being posted to Leicester or Loughborough or wherever. And this was replaced with a thing called Core Case Data, CCD, and it would enable the tribunal to communicate and serve and receive documents electronically. And now we've got the My HMCTS portal, which all professional representatives have to use unless they can show a good reason not to. Now, I'm going to be looking at how the reform program works, starting with the initial notice of appeal being communicated to the first tier tribunal. Now, one significant difference at this stage is that the tribunal procedure rules were amended. Rule 19.4 was amended to replace the requirement to set out the grounds of appeal in or attached to the paper appeal form, with a requirement now simply to identify the statutory ground of appeal being relied on. So this will be either under the Refugee Convention or under humanitarian protection or under Section 6 of the Human Rights Act. So those are the statutory grounds. And as a consequence of that, all you need is the statutory ground, Section 6 or the Refugee Convention, etc. This is emphasized in a practice statement, number 1 of 2022, from the then president of the First Tier Tribunal, Judge Michael Clements. And this states, grounds of appeal are not required when a notice of appeal is provided to the tribunal in the online procedure. Now, that has escaped the attention of many solicitors, and they still, when giving notice of appeal, include very full grounds, page after page. And they also bring in grounds of appeal that haven't been around actually for a very long time, not since 2014, when they say things like, the decision is not in accordance with the rules or the law, or a discretion under the immigration rules should have been exercised differently. Now, these grounds of appeal were all swept away in 2014, but they're still being quoted by some solicitors. And one that particularly took my fancy, which I've seen, reads, the respected judge is humbly requested, I like that, the respected judge is humbly requested to issue directions for entry clearance to be granted. Well, immigration adjudicators did have the power to issue directions for entry clearance, but not tribunal judges at the present time. Okay, so that's the first stage. You give notice of appeal. You have to state briefly, you know, is it a human rights case? Is it a protection case? Or indeed, is it an EUSS? So is it a European case? But that's all. And no grounds apart from that are needed. Now, within 28 days of a notice of appeal being lodged, a respondent's, well, within 28 days of receiving notice of appeal from the tribunal, the Home Office is supposed to provide a respondent's bundle. And this bundle is prefaced by a PF1. Sometimes it's actually called that. You could see PF1 at the top of the page. Sometimes that's not there, but basically it just gives some details about the appellant and the immigration history of the appellant as recorded in the Home Office records. And it always intrigues me how many people are making or have made a further application after having applied several times already, each time being refused, sometimes with a right of appeal, sometimes not. Sometimes it's asylum, sometimes it's European, sometimes it's human rights, but the years go by and every so often another application is made and refused, and lo and behold, the person is still here, which chimes in with, I think, many people's experience that actually very few people are ever removed. Once they're here, they're here. And the problem is that, okay, they're here, but they can't regularize their status. Now, because the appellant will have no declared income, he's very likely to have been granted a waiver both of the application fee and of the immigration health surcharge. So that means that all he has to pay is the solicitor's fees. So he's got nothing to lose except that. And maybe this time around he will succeed. If not, well, at least he's bought some more time for heading towards eventually, if all else fails, eligibility for the 20-year rule, as people still call it, whereby, provided he hasn't blotted his copybook too badly by committing criminal offences or the like, he may well get onto the 10-year route because he's been in the UK for 20 years. And I sometimes hear this from solicitors who are explaining why they're making another human rights claim. And I say, well, it's got very little chance of success. And they say, but it's going to buy more time for the client. So in a way, that's true. It buys more time on the way to the 20-year point. And besides, lawyers have to make a living too. So there we are. Anyway, I just mentioned here, this is academia compared to real life. An exam paper set by the Chartered Institute of Legal Executives, who do have an optional paper in immigration law for people who are studying towards fellowship of the institute. So they can choose immigration as one of their optional subjects. And there was a question I saw in which the imaginary client is found to be an overstayer, and he's taken by border force to an immigration removal centre, and he's shortly to be put on a flight to his native land. So what can be done to prevent this? Oh, I suppose the commonest answer would be claim asylum. But anyway, there's far less, it's far more likely that he'll be released into the community than put on a plane. Now, here's something in the PF1, which is quite intriguing. There are two standard paragraphs which appear in nearly all of the PF1s which preface the respondent's bundle. And one of them states the law quite correctly. The respondent has not received any substantial grounds of appeal at this stage, right? And therefore a bundle has been produced to meet the requirements of Rule 23.2, that's for overseas applicants, and the individual notice of directions for this matter. A full review will be undertaken upon receipt of an appeal skeleton argument or the appellant's explanation of case and any accompanying documentation, which may enable the respondent to revise the position with regard to the appellant's case. Now, that's all absolutely correct. If it was an in-country case, the reference would be to Rule 24.1 rather than 23.2. And this absolutely accords with practice statement number 1 of 2022, which we've already seen. The respondent's bundle is only required to include the application itself, the visa application form, and any supporting material that was submitted, also, of course, these days electronically, scanned and uploaded. So the respondent's bundle includes the application form, the supporting material, and of course the refusal letter. So the next stage is getting an appeal skeleton argument. So even if grounds of appeal have already been furnished with the notice of appeal, the Home Office is entitled to wait for the skeleton. And according to the practice statement, where the appeal skeleton argument refers to material which is not included in the respondent's bundle, that material must be provided in an indexed and paginated bundle at the same time. So that is the appellant's bundle. And it either includes the skeleton or the skeleton accompanies it. But the appellant's bundle often includes unnecessarily everything that's in the respondent's bundle. Although it's specified in the practice statement that the respondent's bundle must include the refusal decision and any material submitted in support of the application. So in the generality of cases, there's no need at all to reduplicate this stuff in the appellant's bundle. Nevertheless, that's very often or usually what happens, and you find that the stitched bundle, the hearing bundle prepared for the appeal hearing itself, contains far too much stuff. And I've seen in one stitched bundle, I saw the appeal skeleton argument 5 times. Yes, 5 times it appears in the appellant's bundle. What can be done? Well, as we see in the next paragraph, it does sometimes happen that the respondent's bundle fails to arrive. And that's provided for in the practice statement. The skeleton must be provided not later than 42 days after the notice of appeal has been sent in, if by that stage the respondent's bundle hasn't made an appearance. So in that situation, of course, the solicitors can't be sure what will be in the respondent's bundle when it arrives. And so out of an overabundance of caution, they might want to put everything into the appellant's bundle. Unfortunately, there is one criticism which I would have of many witness statements in the appellant's bundle, and that is that they don't just say what the witness knows about the situation, about what happened and so on, but the witness statement is turned into a form of pleadings in which a legal argument is made against the respondent's decision. And it's obviously not something which the witness himself has set out. It's been fed, well, it's been put down by the solicitor and then signed by the witness. Sometimes you even get case law being cited, whereas the witness doesn't speak English, has no idea about English law. And it looks bad. Another criticism is that even if it's not in the form of pleadings, the statement is long on vague assertions and short on hard facts. So the witness may be very critical of the effect of the decision on his family and maybe lamenting loudly about that, but not being very specific about who did what when. So what happens if the barrister at the hearing wants to elicit more information from the witness than is included in the statement? Now, counsel will be up against Part 5 of the Senior President's Practice Direction of the 13th of May 2022. Now, this was issued at around the same time as the practice statement of the President of the First Tier Tribunal. Now, this says that a witness statement should be capable of standing as the totality of the evidence in chief of the person giving that statement. Only in exceptional circumstances and with the leave of the tribunal will a witness be permitted to provide additional evidence in chief. So if a HOPO or counsel is there to represent the Home Office, of course, very often an independent barrister will be instructed on behalf of the Home Office. So if there is somebody there to represent the Secretary of State, the missing information may be elicited in cross-examination, but often there's nobody to represent the Home Office. So if the judge needs that missing information, he may more readily give the appellant's counsel leave to put additional questions, or indeed some judges are very willing to put questions themselves. Well, that's not so bad, but other paragraphs on the face of them impose quite severe burdens upon appellants and their representative, well, particularly the representative. The witness statement must be in the intended witness's own words and be drafted in his own language. It must be the equivalent of the oral evidence which the witness would, if called, give in evidence. There must be a statement of truth in the witness's own language. And of course, there must be a translation. And that must be certified by the translator, who would be a professional. So all of this would add a lot of extra cost, which would fall upon the client. The solicitor would charge the client for all this stuff. And the outcome is, in fact, that in practice, this isn't done at all. And the old practice has persisted that the witness is shown a statement in English, and he's asked to take a look at the last page, and he's asked, do you see the date at the bottom and the signature above that? Is that your signature? Yes. Has this statement been read to you in your own language? Yes. And are you aware of the contents? Yes. And are you content for this statement to be your evidence for the judge? Yes. Right, all done and dusted. And that's still done in the majority of cases. And it seems to me that it's something which immigration judges are just turning a blind eye to. They're not going to make an issue out of it, fortunately. So I've only ever seen one or two judges complaining during the hearing that the witness statements do not comply with the senior president's direction. Okay, well, that's the stage of serving the appellant's bundle with the witness statements, and of course the skeleton. It's called an appeal skeleton argument if it's done by a professional. If the appellant is not legally represented, it's called the appellant's explanatory, what is it? AEC, appellant's explanatory something. Yes, not statement. Let me just look at my own handout. Explanation of case. Appellant's explanation of case, that's it. Now, the Home Office have a team which will review the case in due course. But returning to the PF1 in the respondents bundle, we have also, we've already seen the paragraph that talks about a forthcoming review, but further down there is another standard paragraph, as you'll see, which says this: please be aware that ALAR, that's the Appeals, Litigation and Administrative Review part of the Home Office, are operating a facility to review new information or other substantiated requests for reconsideration of decisions that have an outstanding appeal before the first-tier tribunal. Such requests should be submitted 6 weeks before any hearing to, and here we have the email address, appeals reconsideration requests at homeoffice.gov.uk, clearly setting out the reasons why a review is appropriate and accompanied by supporting evidence or documents. Now, this isn't the only place where such information, this similar paragraph, is to be found. So, for example, if you contact the Home Office Directions out-of-country inbox, you get the following auto-acknowledgement as confirmation of receipt. So it refers to receiving the skeleton, and in fact it's only for receiving the appeal skeleton argument. That will be passed on to the appropriate team. If it's a request for the respondents bundle, that will not be forwarded on, and you're invited to contact the SART, I think that's Sheffield Appeals Review Team bundle requests, for requesting the bundle from Sheffield. And if your inquiry is to request a reconsideration, please resend your email to Appeals Reconsideration Requests. Well, but if you do that, if you do email that Appeals Reconsideration Requests address, you get the following automated reply: this inbox is no longer monitored. Any correspondence received in this inbox will not be responded to and will be deleted. All reform appeals lodged via My HMCTS will be reviewed as part of the reform process. So, in other words, there is no appeals reconsideration requests team at all. And there hasn't been for years. Well, not for a couple of years anyway, because there's no need for reconsideration. That job is done by the respondents' review. But however, this paragraph about a reconsideration is still there, and it's completely inaccurate. And why it hasn't been deleted, I don't know. It seems to be just nobody could be bothered. Inertia is part of the bureaucratic culture. Okay. Oh, there is more about the reply to the email telling you where you should go instead. Okay. Well, anyway, the Home Office people that actually do carry out the respondents' review used to be called the Sheffield Appeal Review Team, SART. They're now called the Pre-Appeal Review Unit, PARU, and they apparently are more experienced caseworkers, though sometimes one is not too sure, given the quality of some of the respondents' reviews. Now, here's an example of a respondent's review, and you see that the schedule of issues mentions 3 things, and they're all taken from the skeleton in the appellant's bundle. Now, this is followed by a counter schedule, which repeats the issues already listed under the schedule borrowed from the appellant's bundle. And it simply says that the grounds of the reasons for refusal letter are maintained under all 3 of the issues. So the schedule of issues has simply been lifted from the appeal skeleton argument, and the PARU staff evidently think that a counter schedule is the cover term for their arguments against what has been submitted in the skeleton. There is no disagreement as to what the issues are in the appeal. Now, it appears to me that there's been a misunderstanding of what the meaning of counter schedule is. And actually, what it means was set out in 2020 by the Tribunal Procedure Committee. And basically, they said that if there's anything in the schedule of issues provided by the appellant that the respondent doesn't agree with, then the respondent should provide a counter schedule with the different issues that the respondent thinks are necessary to decide at the appeal. So if the respondent simply agrees with all the issues listed by the appellant, there's no need for a counter schedule at all. So, but I don't think anybody's going to be very fussed about that. So we've come to the end of the stages set out in the President of the First-Tier Tribunal's standard statement, giving the stages which should be gone through, and then after the respondent's review, nothing else is included in the President's practice statement. But is there actually an extra stage not in that practice statement? Well, There may well be, because you will very likely have received an email from the notification service. And this goes something like, you have a direction for this case. The Home Office has replied to your appeal skeleton argument and evidence. You should review their response. Okay, so you can respond to the respondent's review. Next steps, review the Home Office response. If you want to respond to what they have said, you should send the tribunal, you should email the tribunal. And if you do not, the case will automatically go to a hearing. So you've got a certain length of time to respond to the review. Now, it's in a way, it's a peculiar direction because it's entirely voluntary. You don't have to respond at all. And as I say, it's outside the schema outlined in the President's Practice Statement of 2022, but it's reminiscent of something which is in the upper tribunal procedure rules. Now, Rule 23 says that the application for permission would normally stand as the notice of appeal, and this actually, well, it must give substantive reasons why the first-tier tribunal made an error of law. That's in the application for permission to appeal. So this now stands as the notice of appeal, but because it gives the grounds, it's akin to the skeleton argument in that it's telling the upper tribunal why they should overturn the decision of the first-tier judge. Now, Rule 24 requires a response to the notice of appeal, or allows it. It's not necessary, though. Even if you're not going to respond to the notice of appeal, you're supposed to tell the upper tribunal that you're not going to do that. So it's a bit like the respondent's review at the first tier. It's countering the argument in the application for permission, just as the respondent's review is countering the skeleton argument. And then Rule 25 permits a reply to be provided to the Rule 24 response. So this is like the extra stage that we've got at the first tier. You can take the response, you can criticize the response and try to argue that its arguments won't stand up. Now, actually, a response to the respondent's review can be a very useful thing, because the review may actually be introducing different grounds for wanting the appeal not to succeed, different grounds from those in the original refusal letter. So if that is what has happened, if the respondent's review introduces new reasons for the appeal to be dismissed, it's a good idea to send in a response to that and counter it, and that will make the judge's task easier. Well, there we are. Let me just check. I'll stop sharing at this point, and let me just check what we've got in the Q&A. There are still 73 participants. My goodness, that many people have stayed on till the bitter end. I don't think we've got anything about my talk. But we have one or two nice comments. Thank you for such a good course. And thank you all. Thank you all, panel members. Well, thank you all for staying on for this long. And I hope it's been beneficial to you. And I hope that you will come back for more next time. And don't forget, if you're interested in family law, there is this family law update webinar on the 16th of April. So from me, get my full face in here. Thank you again and all the best. Bye-bye for now.